Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
No, I am not Payne and John Milton. I am the agent authorized to represent Payne and John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Don't miss the forest for the trees.
Who's him?
Don't interrupt.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
Does not want to be represented. Okay. All right. Why can't I hear anything? Are you guys not able to hear? Kim? Who's him? See, I know you can hear because Ashley said who's him. So let me move back where he belongs. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Thank you for joining me this afternoon as we kick off the afternoon session of the Hannah Payne trial. I think we're going to be in jury selection, or not jury deliberation, very soon. Let me turn that down just a little bit. That's deafening. I apologize. If you didn't hear anything I said, that's all right. I didn't say anything super important, but we will here shortly. First of all, Florida is a go. We will be going to Florida. I've got a couple things to sort out. Like I need to overnight a cable. Believe it or not, I need a cable. I don't have enough cables. I need to overnight a cable. We'll be going to Florida. We're going to be staying. It's going to be a quick hit, a quick turnaround. Drive down. It's 10 and a half, 11 hours, depends on the time of day you drive. So it's a long drive. I'm not sure if I'm going to rent a vehicle to drive down because it probably gets better gas mileage than my vehicle, or if I drive my own. I think it's a little bit more expensive to rent, but it might be a little more comfortable because it's a nicer vehicle. We're gonna stay the night. We're gonna be there at the courthouse to get the live feed from the news media room. I may not be in the courtroom. It depends what has to work out, and I realize there's been some offers there, people who volunteered to say they can help me out a little bit with that, and I just don't know how that's going to go, how that's going to play out. Can you hold up a sign for the judge like on Good Morning America? No. If anything, I'm going to be looking quite sharp. I think I'll be wearing my pickle tie. I think that's about the most I could do is wear a pickle that says "deal with it," right? That would still be court approved, right? That's not like too much. If I'm wearing a white shirt, and I don't bring like I'm not going to be like sitting there and playing sound effects in the courtroom. So no, I'm not going to be doing that. I have way too much respect for the court process.
How does he do that?
Red Pen, thank you very much. Gas money for the Sarasota trip. Thank you, Red Pen. That's going to make it all possible right there. We'll be going down. Dr. Corcoran will be there. We'll be headed down to Sarasota. I'm going to stay the night in the hotel there. We're Mrs. R.A. right now.
Don't miss the forest for the trees.
Oh my goodness, that was loud. Mrs. R.A. is right now shopping for looking to see if there's a better vehicle that I can take that will make it cheaper. Because I'm all about saving money. I can't see wasting money if we don't have to waste money. So either my own vehicle or rent one. We're going to spend the night there in Sarasota, probably as close to the courthouse as we can, so we can get to the courthouse nice and early and be there to set up in the media room because we obviously want to. We need access to the feed. That's the whole point. We're going there, and then we'll be
scratch all that.
I'll be there for 4 hours. I might be able to make an appearance in the courtroom. I'm not sure. But either way, we're going to see. I don't know. I'll talk to Rob, or possibly we'll talk to another creator to see if we can do a joint stream. So somebody would be streaming and sharing it to my feed, as well as I might be able to call in during breaks or things like that. So it's a little crazy. It's a little convoluted, but I think we're going to pull it off. We need to before we go anywhere. Adam.
When are we going to break for lunch, Judge?
When are we going to break for lunch? Let me just pull this up because Adam, according to my records, which are not wrong, you were first in chat this morning. I'm not a cat. Like with this one right here, Z. Meaning I think the Z is a banned letter, Adam. Congratulations, Adam. Being first in chat means that you have won the internet. Are you going to re-gift it? Are you going to re-gift it? Because I see some things between you and Megan as far as trying to pass something. Megan has won the internet from me. All hail Megan, says Adam. Okay, so Megan, congratulations. This is a repeat for you. I've never had somebody win the internet twice in a row on a gifted, like on a re-gift. That's like winning the White Elephant Exchange, and nobody does that. But yes, congratulations, you've won. Good job. You know what to do because you did it all morning. You did fantastic. So thank you very much, Megan. Make sure you get your collector's edition certificate commemorating your win. It's available for 50 cents and a download, and then you have to fill it out yourself. Hey, that's how we talked about saving money. There we saved money. All right. I have the Screaming Goat. Yes, someone sent me the Screaming Goat. Thank you very much. Mrs. Ure can be a guest streamer. I don't think she wants to, but she could. There's a thought. True Crime Junkie says, for snacks, gas. Thank you very much, True Crime Junkie, the OG. Appreciate your support, all of you. Krista as well. I want to sit and you won't let me. Is the seat not working? Krista, what happened? I think it's seating. All right. I'm behind. That's why. Let's see. Maybe Matthew could be a guest speaker. It's short notice, and I realize everybody has a job except for me, right? So it's a worst case scenario. We're going to live stream it without commentary, so you would just get what's happening. Dr. Goodhair is streaming after the hearing. Maybe you can get together. Go on bus, save loads of cash. It would take 30 hours to go on the bus. That's 3 times as long as driving. Krista's been standing for 2 days. Don't know why. This is Samantha. Krista, take a seat. Take a seat.
Is that correct?
All right. Krista, try this right here. Exclamation point seat. Let's see if that works. Or are you not in green right now? There you are. You're in green. You can take a seat, Krista. It's all right. All right. I volunteer as tribute. Thank you very much. We're going to make this happen anyway. I wanted to share that with you. I'm super excited about that. It's always awesome. We're doing better at getting access to courtrooms through media requests. And as this improves, this is what I've said for the last year, that I want to take my channel more and more to be involved and personally and possibly even get cases that the other channels are not covering, where we would have equipment in the courtroom where we're capturing it and providing a stream that way. So that is what we're working towards. That's the long view. In the short term, it's probably going to look more like us possibly getting a couple more live view devices and sending them out to different courthouses where we have volunteers who represent us as a media person who just plugs it in, and then we run it remotely and live stream from different courtrooms. So that's probably how it's going to look in the short term. And this is a dry run of that. Well, not a dry run, it's a live run. Let's see. I'm very confused about what's actually happening Friday. Can you summarize? Teddy Bear, what's happening Friday? We have what's supposed to be a 4-hour hearing in the Maya trial, where the judge is going to be hearing arguments and listening to arguments about all the motions that have been made right before the trial ended, including up to right now. So all the motions by the defense, the motions for directed verdict, the motions for a new trial, the motions where they complain about juror number 1 and Jules and me and lawyer and Rob and everybody else, all those motions and all the responses are all going to be heard. And so it's not a huge day as far as decisions go, because the judge is going to take his time and then probably issue a decision. But it's a huge day as far as argument goes, and it will be spicy that way, because the two teams will be either on Zoom or in the courtroom or a mix of both. And this is they're fighting to not have to pay the verdict. They're fighting to not have to pay the $261 million. And if they can win these things, then they can get away from that. So it's like a last gasp, I think. And
scratch all that. Oh, that was terrible. I apologize.
It could be very, very big for this case. All right. But what am I doing?
How does he do
Teddy
that?
Bear, I'm going to get the live stream. Right now, it's only available on Zoom, and you're not allowed to live stream it. That's currently where it stands. what's in the works is we may have a pool videographer there that may or may not be live streaming it, and so we're going to go and provide a live stream so it will be available for you guys to watch.
You need to see.
That's what we're doing. And I have the equipment to make that happen from the courtroom, so it can go from the courtroom straight to YouTube, and you could see what's happening.
They'll install it as well.
So I figured you guys would want to watch this. So that's our goal. All right. I think I've got like a Charlie horse in my butt. I know that's too much information for you guys, but it just happened and it hurts. I needed one of those massage chairs. Sorry, guys. That was inappropriate. I should not have mentioned that. All right. Do you have redundancy for your cables? I have redundancy for my redundancies. That's what we're going to do. I've got 3 different ways to power this, 5 different ways to access the internet, literally. Yeah, it's going to be good. All right, Flex. I have all the cables. Tayo, of all the times, if I could beg you just once, Phil, to use discretion and maybe leave a little bit on the cutting room floor.
Scratch all that. Oh, that was terrible. I apologize.
That would be the moment. Right there. Heather, snack money for your trip. Also, please roll your eyes in the defense's direction. Drive safe. Thank you very much. We're getting ready to go back to court right now. Let's see if we can check in. There's where we are. We're getting ready to go back to court, but
there's a lawsuit.
What we expect to hear when we come back is going to be the wait till you drive 11 hours. This is why I need a comfortable car.
We're talking about stuff that is not relevant.
An 11-year-old car that is an SUV is probably not the vehicle I want to take on that road trip. So the bling bling says, here's what you do. Just stand up and twist left to right a few times. I actually just twisted in my chair and it fixed everything. Let's see. Daily Watcher says, Recovery Addict, those pickles were terrible. New Mount Olive Magistry are incredible. Daily Watcher, you tried the spicy maple bourbons and were not a fan? I'm sorry I led you astray. I honestly thought that everyone who tried them would love them. I need cruise control. I need lane assist, Melissa. See, can you make that happen? How will you make that happen? Butterfly Girl, let me show you really quickly.
Are we going to address subject matter jurisdiction?
I'm not a camel.
Just a quick little side shot here. We're not going to miss anything from court, I promise. This is a few $1,000s. Each one of these little black things, 1, 2, 3, 4, those are agnostic modems, meaning they will connect to every carrier in the United States. And I believe you can get them internationally as well. But any internet carrier out there, this will access. It doesn't matter, AT&T, US Cellular, Verizon. If there's a signal out there where I can get a good connection, it will get to the strongest one, and it will take all those signals and it will bond it together in this little nifty device right here, which I can feed in either through HDMI or SDI input, and it takes this and it puts all the connections together and gives me an excellent connection to the internet where I can send this video to YouTube. So I have to get this to the courtroom and plug it in to get the feed. Then, of course, I have to be there and sit there and watch it and make sure everything's working right and know how to set it up and troubleshoot. But that's what I do. It's a power belt. It is. This is the longest, shortest trial ever.
Someone with more experience.
Thank you. Cam Hope, Bucky's treat. I've got to figure out where Bucky's is. Apparently, there's one on the way. So we are going to Florida. We're going to road trip. That's what we're going to do. Tiara, how much is that? $3,000 for the equipment and $600 a month for the data. So it's not cheap, but this is the direction I wanted to go. I do have a PayPal, if I can remember what it is. I realized some people were asking about that. Let me see if I can find it. I don't know how to find my PayPal. My PayPal has my whole name on it. That's what it is. How do I... This is all I know right here. Ready? Let's see. Your code. Scan to pay. Ready? Let me show you. This is all, and if you guys can see what it is from here. I'm on camera 1 already. Does that say who I am? Is that clear? Sorry, there's messages from Weather Watch on there.
Alex stole it.
That's all I've got. I don't know what else would indicate. That's what my profile looks like. Does that tell you? I don't know. I don't know what my PayPal is other than that. So if somebody can tell me what my PayPal is or how I can send that to somebody, let me know. I think it's in my link tree. I don't think I know how to get into my link tree anymore. I've lost the access to that. All right. Use the link on your info page. Hey, I didn't know it was on my info page. There you go. Thank you very much, Dilly Pickles. If you can direct other people to that, that would solve the problem. All right. We are going to go back to court here as Hannah is getting ready to hear her fate. I guess the jury instructions come next. We're done with the witnesses now.
Because he's the guy.
And then we're good to go. PayPal address is just the email you use in the PayPal account. I don't know which one to use. And I'm not sure I want that email address out there. My good email address? Man, that is a... Could I add a new email? Add a new email address. MD Recovery Addict at gmail.com. Looks like something went wrong on our end. MD Recovery Addict at gmail.com. Add. Doesn't let me add email.
Scratch all that. Oh, that was terrible. I apologize.
Okay. Yeah, it doesn't let me change my email address for some reason. All right. Ivan says, I am now Scott Victor. Thanks. Someone with more experience. Thank you, guys. All right, here's where we are. Court's about to begin in about, well, we're 10 minutes late coming back from court, which has been the normal for this court. Almost every single day, almost every single break has been longer than it's been announced for, and jurors have been late. A juror was an hour late to trial today, and the judge said, hey, just remember, when we say be here at 8:30, that doesn't mean 9:30. Thank you. And that was it. So, okay. Which juror is late this time? I wonder, we had... Actually, this was actually a surprise. We had the judge announced earlier today that one of the jurors had been approached by someone, probably someone in the audience, I'm guessing, not one of the attorneys, because that would be really wrong. That's like disbarment type stuff. But he's the guy. Does that mean it's bench warrant time? It could be. The judge has the authority to do that. But there's someone approached the juror and tried to contact them or tried to talk to them in some way. And it might have been completely harmless. It might have just been, hey, how's your day going? And they recognized that it was someone from the gallery, or, you know, hey, they might have said, hey, you're one of the jurors, right? That would be inappropriate. Okay, the judge has a lovely voice and demeanor, but I'd love if she could tighten things up a bit in the courtroom. Future, I agree. The timing mostly is what we have a problem with.
Stole it.
Go to About, then Linktree. Let me look at my account here. You guys are telling me where my account is. YouTube, Turn this off so it doesn't make noise. View my channel. I'm not seeing about on my page. Oh, the over, about, there it is, the over arrow. About, then link tree. And it's, okay, I see it. I see where you found it. So you can get there from YouTube. Thank you very much. I didn't know I had this on here. Still, I thought I deleted it.
You're talking about stuff that is not relevant.
All right, so we're waiting for a judge to come back, and then we'll begin. Could have been car trouble. It was freezing this morning in Georgia. They've had some weather moving through, as Tennessee knows all about with that huge tornado that came, the tornado stuff that went through.
Squirrel.
Lisa, I will be able to stream, but I might not be able to have my picture on the stream. It depends how the jury or how the newsroom, the media room is set up. I'll be having the live feed, so you'll be able to see live from court. That's according as long as the pool photographer shows up. I'll have the live feed, and I'll be able to watch what's happening.
Are we going to address subject matter jurisdiction?
And I'll be able to bring that to you live. So it's not like you have to watch Zoom.
When are we going to break for lunch, Judge?
Can we do birthdays for Friday tomorrow? We're going to have to, I think. Trial time, Tammy. We're going there for the Maya trial. I realize the trial is over. The verdict is in. The jury has spoken, but there is a hearing that involves all the motions that were made after that. And they're the spicy motions, the things where they complain about juror number one, they complain about Jules, they complain about all the discussions that happened on all the law tubers and my channel. Lots of stuff going on, and it's going to be a very spicy hearing. It should last about 4 hours. That is the case number if you need the Maya trial case, but that's the official docket number, 2018 CA 005321NC. All right. Will there be no podcast on Thursday? It might be from the road. Well, I'll have to talk to Weather Watch and see how we can do this. Yeah, I applied to the court and asked for media access and was granted that just this week. Mama 3, I probably will pop in the courtroom for a little bit, at least just briefly. This is the second comment like this that we've had from you today. They're great comments. Thank you very much. All right. What time on Friday? Friday, Georgina, everything's supposed to start in Judge Carroll's courtroom there at 8:30 in the morning, and that'll be in courtroom 6D. If I'm not mistaken, that's the 2002 Ringling Road address, that courthouse. I'm hoping not to stop anywhere other than get gas and maybe a little bit of food and you know, the necessary comfort breaks. I think it's 6C. I will confirm that. You probably know because you're on that page right now. I'm just logging back in. You know what we didn't do today that we were supposed to do, Greeners? I think you were supposed to remind me, and I'm going to throw you under the bus for that. I think we were going to talk about Sarah Boone, because there's a new document that was released in Sarah Boone. It's not a letter, but there was a document released where her defense team is asking the court for some additional money to pay a private investigator. Which private investigator? Probably the best money can get? No. She's still after that prison break guy. She says it's you know, detrimental. It's very pertinent to her case. She needs this guy to do some investigation. How much? Well, at $50 an hour, it will only cost $7,500. $7,500 of fees to be paid to a private investigator so they can investigate what they need to do before her court case in January, if he's able to do it in time. Let's see, doing the math, is that what, 140 hours of work Is that right? Just in my head, 140 hours of work. Divide that by that's like 4 weeks of nonstop 40-hour a week investigation that he's going to do between now and then to get her case stuff figured out. Why can't you stream it from your place? It's a long story, but it has to do with the way that things are being handled during this trial, and it's something I've worked out with the court, and it's just important. Charlie, where spot breaks. I should not have said that, guys. I have no filter. That's the problem. Positive vibes. Thank you very much. Yes. Let me see. We just have Lisa, Stephanie, Buffalo Weekly. Thank you. I appreciate the help via PayPal. That will be most beneficial. Sarah Boone. What did I not say? Did I say someone else? Did I say Hannah Boone? I meant Sarah. Hello from Hawaii. Hello, Kevin. It's actually Ringling Boulevard. Okay, it's Ringling, though. It's a circus down there, whichever one it is.
What more do you need to see?
Greeners says, I only mentioned to you about 3 times in chat last stream. I know. I'm sorry. So 8:30 a.m. in Florida is 7:30 a.m. in Central Time. Isn't it Central Time there? In Sarasota? Is that Central or... isn't it Eastern Time? Yeah, so 8:30 a.m. Eastern Time in Florida is 7:30 a.m. Central Time. Witchy Mama, that's correct. Sorry, it took me twice to reread that. Joe says, gets named in a court motion, applies for media access to that court, Frost defends his cookies, a way to make a power move, RA. Yes, that is exactly how it went down. I literally called him up and said, look, I was named in a motion. The judge is going to be hearing on Friday, and I need access to that as media. I'm like, well, the media has this. And I said, I know all that. I have all the equipment. I'm telling you, I'm media. I need to come down and get that so I can live stream it to my my viewers. Oh, okay. Yeah, we'll put you on there. It was that easy. Can someone give me a quick recap for this trial for today? Are we feeling not guilty or guilty? I found her credible yesterday. Kel, very quick recap. I also found her credible. Unfortunately, I found her credible when she was telling a different story as well. What does that say about me? I don't know. It's going to be a tough one. She contradicted herself between when she was on the stand and when she was in custody for an interrogation, and it's big things.
Before we broke for lunch, I instructed the jurors that once we got back, we'd be doing closing arguments. Is the state ready to proceed?
State's ready, Your Honor. Attorney Tucker.
I talked to the IT guy. I couldn't pull the presentation on my computer in my office. I needed him there, not here. So I'll proceed. If someone does walk in, I told them to just hand the paper.
Ben is here.
And that's it. I couldn't get the power on my computer at the office. Somebody tried to defrag it last night or something. So
he said
I've
defrag.
asked that they get it to work to print it and bring it to me. So if they do, I just told them to get the lady in the back.
Okay.
And it would be not on the screens.
Okay. All right.
Okay, we can bring the jurors in.
Barbara, you'll be able to watch on this channel. We will be bringing the stream right to this channel, either through StreamYard, possibly with the help of another streamer. I'm not sure if Rob's available or not, or possibly just without me giving commentary, but the stream will be here with the same chat and the same mods, and possibly me in chat as well. Judy says, if it was charged differently, I would be more inclined to say guilty. A lot of people are saying guilty. I had a hard time finding malice, but now I'm leaning more that I can see the jury finding guilty across the board.
Ladies and gentlemen of the jury, before we broke for lunch, I indicated the process that would commence after lunch, and at this time the state is going to begin its closing arguments, and the defense will have an opportunity to do so as well, and then the state will have the final closing argument. So I'm going to ask them to do that at this time.
The state will reserve.
Okay. All right. Attorney Tucker?
The state reserved. I've never seen them not give a closing. At least not first. They're going to give their whole closing at the end.
Ladies and gentlemen, 2 weeks finally get here. And as I stated as we began, that the judge would instruct you on the law, the judge would instruct you on the roles, and the judge would give you guidance to take all that you've heard, all that you've seen, all that you've been through this last week and a half. And I told you that I would try to get as much evidence out so you could see the full picture. Because as I said, when we're dealing with the verdict, you must honestly be seeking the truth, wanting to hear more, wanting to see more, wanting to see the full picture of what happened, to hear what really happened, why this occurred, how this occurred, and why not. So as we began, we started with the opening. Of course, I gave you a little story out there to try to keep you interested. And I think we got more to talk about than that bullseye. So I want to go through what you saw here today, because the judge is going to say everything I say, everything the state says is not evidence. So you to disregard it. But I don't want you to disregard what I'm saying, because I'm not trying to say is evidence. I'm just trying to be a highlighter. From all the evidence we were able to get out, I just want to be able to highlight it and say, this is what I felt was important. This is what I think you would want to know is important. And then it's up to you to decide. Was it important? Was it not? Was it something that I needed to see? Was it not? So we started off fully understanding that the state has the heaviest burden in the world to prove all this evidence of what they have put in the indictment beyond a reasonable doubt. You probably heard things like probable cause, which is a very low threshold. Preponderance of the evidence, if one has 51%, they win. And then reasonable doubt being the highest standard out there. And the judge is going to read to you what reasonable doubt is and what classifies something that is reasonable or not. And I'll let her go ahead and do that. And I won't try to waste your time with that, but I will start at looking at it as a heavy burden the state had to prove. And they brought up the first witness, and it was Mr. Herring's sister. And she got on the stand, and she showed a picture of her brother, God rest his soul. And she talked about how she knew he had diabetes. She knew. She's a sister. But that standard is very high, beyond a reasonable doubt. Why wouldn't a doctor come in here and say, I have been there, I've tested him, I've seen it, I've instructed him what to do, and he has diabetes, and this is what diabetes does, and this is how it affects you, and give you everything so there's no question of what diabetes does. There's no question of why there's needles in the vehicle, so many of them. There's no question on how somebody would feel if they had high blood sugar or low blood sugar. We didn't get that. And from there, jumped right into Mr. Robinson, Terry Robinson, that state official. And he comes in and he says, you know, I was there at the accident. The first accident that involved Mr. Herring and Mr. Stanley Kimball. And Mr. Kimball was not here to testify. And Mr. Robinson said, Mr. Herring was walking around his vehicle. He saw him run the red light. Saw him hit his 18-wheeler. Saw Ms. Payne there. Pull over, concerned, see what's going on. Everybody okay? And he starts talking about something's wrong. Something's wrong with him. And in the 911 tapes, you hear him going back and forth with an exchange. Doing something wrong. Did you do something wrong? Is it a crime? And him saying, sir, you just... And he stopped. He didn't say run the red light because he knew it was on the phone call with 911. He didn't want to prejudice that case in any form or fashion. But he saw what he saw. And then when he's talking to Mr. Herring and telling him, stay away from the car, that thing's about to blow up. I mean, it's smoking, radiation fluids coming out of it. It's not reasonable to think somebody could just hop in that vehicle and just drive off. But yet, his testimony was that he walked around it, he made sure the tires were okay, nothing's going to stop it from moving. He got in it and revved it up. He revved it up and you hear him on 911, sir, get out of the way, move out of the way. Get the tag, get the tag. And he says he gets in his vehicle and starts driving off. There's no reason given. There's no doctor to come in and say, well, this is what occurred. It's just the individual who's a state official, who we find out later is a correctional officer, but who gives his account of what occurred. And when talking with him at the stand, what he had said at the incident location and what he had said the day it happened, it was a little bit different. He was using words like confused. Wasn't really doing much. Kind of just out of it. Now, he himself, even though he is working at a medical correctional facility, he doesn't have any medical training. He doesn't know what to classify, what to look for, or what to do unless somebody comes and tells him that this person has a disorder, or this person has needs, special needs, or this person needs this. But yet, he wants to give examples of confused, out of it. Whereas in his statements in the report and his interview at the precinct, he was irritated. He was walking around the vehicle. He was looking into it, trying to get into it, looking to see what's in it. Then he cranks it up, and he revs it up, and he drives off. So that's how it all begins. And in the meantime, he's on the phone with 911. Miss Payne's on the phone with 911. And they're talking to them both. And the one thing both of them wanted, and the one thing 911 wanted, was that tag information, the tag number. Now, you heard testimony that he'd already caused one accident. And she was looking out for safety. Now, smartest thing in the world to do, to get behind a car from somebody who's being erratic, somebody who's leaving the scene and you got an officer telling you not to, it's not the smartest thing. But when you have good intention in your heart and you're trying to help somebody, and you don't think, she's never been in an environment or a situation to ever think somebody's going to grab her and say, I got something for you, bitch. She would never contemplate that. So she gets behind and tells 911, hey, I didn't get it, but I'm going to go get it. And you meet Mr. Robbins. Good, go, go, go. But yet he wanted to say, I told her not to go. I told her she shouldn't chase. But you heard the 911 tape. You never once heard him say that. But it was a little bit different, a little bit more biased. And maybe media played a part, maybe memory played a part. But you can decide that yourself. You heard his testimony. And pretty much, besides coming to the scene later on, that's about all he can help. That's all he can add to this story. And he added a little of his own flavor in it to say, I did this and did not. But as we talked when we were choosing the jury, and I said the mannerisms and what you see from an individual on the stand, y'all know if they're telling the truth or not. Y'all know if somebody is not being as truthful as they can or trying to hide something. So they get Mr. Robinson down, and then you hear Miss something. And she's the 911 custodian, operator. I'm not sure it really claimed out what it was, but she works at the 911 call center. And she's there, and she says, hey, we take calls. We record them. We hand them to our upper people, and they make sure nothing alters. They make sure nothing changes. And that's about all she can say. And she says, hey, this 911 sounds to be in the same shape, form that we received. But she never received that 911 call. She was not the operator. So we have to just take her word for it. Because there's nothing really to contradict. So she comes in here and gives an explanation of the 911. And we hear it. And you hear exactly what we were hoping you to hear. That very calm voice of Miss Payne. Ma'am, there's been an accident. I don't know if I'm supposed to call you. I don't know if somebody else has called you, but I just want to let you know there's an accident, and this is the location. And later on, as he's walking around, being irritated, grabbing, looking at his car, not answering questions, trying to find out if he's done something wrong or not, then you hear her say, ma'am, it's taking forever. What's going on here? And of course, you heard testimony that traffic was bad and that it was difficult to maneuver to where you needed to. I'm not trying to throw anybody under the bus. I'm just telling what evidence was presented. So this traffic jam and this delay of the law enforcement to come out there and write a report to find out what's going on. In this delay, there was an opportunity, a gap. And in this gap, Mr. Henry decides he's going to go. He's going to leave. And she said, ma'am, I'm safe. I'm in my car. I'm just going to follow him and get that tag number for you. And you did hear her say, ma'am, we don't want you to chase. We just want you to be safe. The second time it was said, they're talking at the same time. So how one heard the other, I'm not sure, but they were talking at the same time. And they were calm. And they were speaking calm and saying, hey, and then there's radio silence. Nobody's saying, stop, you need to stop right now. Don't follow. It's dangerous, you gotta stop. No, nothing. Radio silence. So you think, okay. In their training, they're taught to say, hey, y'all don't need to chase, but we get that tag, We gotta do this so that things don't happen to us. So don't chase, it's our policy, but hey, get that tag. So she's following this car, not knowing, not understanding what could happen, because she's never been in it. She's 21 years old, never been in a situation like that. In her mind, she's a young individual trying to help out. She hasn't seen the bad sides. Heard the old phrase, no good deed goes unpunished. So she's trying to assist, and in doing so, she's hanging back enough to get the tag number. And she does, and she reports it to him. In the meantime, we heard that Mr. Kimball had already got that tag number and given it to Robinson, who gave it to 911. So in this time, Miss Payne is following. Why didn't somebody say, hey, we already got the tag? Stop. No one did. Amongst the confusion, it's still, you're safe, you're behind them, just attack. And then she said, you need to come back to the location. And you need to stop. She goes, man, I'm not gonna follow me. He's already caused one accident. We're the police. I'll just hang back here till the police gets. Now, if the traffic is as bad as they said, what you gonna do? Pull off? Where you gonna go? You got traffic. The traffic wasn't as bad as it was perceived. Because later on you hear Mr. Williams, as he's cruising by the whole thing, puts his hand out there with the phone, takes it on. Didn't look like he was concerned about traffic or anything. When you see the pictures of where the car finally ended up, you see there's a big gap that somebody could have gone around to the right. Mr. Williams is actually going to the left, just videotape it. So you try to take everything you hear and try to visually picture it. And you've heard up to now that he got out of here, or whatever that's worth. Then you heard, well, you know, it was irritable, he was walking around crazy, he wasn't listening to me, he sure as hell wasn't listening to me. But, he's confused, kind of out of it. How that changed, I do not know. How those stories changed. But you, the decider of fact, can take what you've heard and take what you listened to and saw, and you can decide that for yourself. And that's what I wanted. I wanted all the evidence out here so y'all could decide. So after something comes up there with the 911, then they bring McCraney in. And she sits down. She's got a good story she's telling it. She's wound up. She's talking about, yeah, I saw it. It was crazy. She jumped in the window. Now, literally, we don't know. There's no way she could have jumped in the window. But you try to extract from what they say. As we said, every time there's a story, there's a little bit of truth in it. A little bit of truth. So maybe the part that she was in the window is when she's being pulled in the window. Maybe the part that she jumps when she's pulling back and getting pulled in. We don't know. But you heard the testimony the same I did. And you'll get to decide out of that, was it really believable that she came up and said the vehicle stopped like an inch away from it. Vehicle stops like an inch away from a vehicle. It appears they hit, but it was like an inch, so give or take. And then she said she pulled up like a foot, but she was behind the Jeep at that time, and she couldn't see what was going on, but she heard a gunshot. So we got a person jumping in the window, somehow, some way, or whatever, and a gunshot. So we know there's a gunshot. And a lot of people congregate and start going back and forth on who did what, how they did what, and that ends up being the testimony from McCraney. Then you hear a detective Rowland come in and say, hey, I just did my job. I went to the jail, I swabbed her, I'm out of here. Short and sweet. How you going to dispute something like that? If it was done properly, let's get them on the stand and get them out. So they swabbed her. They got DNA. And then you have Ashley Haas. She comes in and she says, you know what? I do fingerprinting. I do that job that everybody always wants to hear. You hear in these shows and movies. Out there at dust, I get the fingerprints, we take the laminate, we look at the genes, the alleles, we look at everything we can. Then we compare. And we compare. The one thing they didn't compare is any kind of fingerprints or any kind of DNA on the trigger of the gun. That seems to be what it was at dispute. The trigger. Who pulled the trigger? What happened with the trigger? But nobody tested it. But they did test the gun for DNA. And they came in and said, there's DNA. There's a dominant DNA and there's a minor DNA. And we all sit here and we learn something new about DNA as we're listening. And they said the dominant's going to be more of one person's DNA than the other. And probably no surprise to you, there's more DNA from Miss Payne on her gun than there is from somebody else. So, but they did say there were 2 males' DNA on this gun. And it was on the slide. The slide, the top of the gun. where the bullet would eject, or the shell would eject once it's been discharged. There's male DNA on it. There's 2 men. So as you hear, as we go further, you hear that there was a hand in the struggle between Mr. Herring and Miss Payne. And his hand got on top of that slide. And they were fighting back and forth. She had a good grip sometimes. She didn't have a good grip sometimes. But there was male DNA. So you can look at it, and as they talk about circumstantial evidence, you conclude that it was Mr. Herring. But who's this other male DNA? Where'd this other male come from? And you heard her say she took the gun off, handed it to Officer Ritchie, who had no gloves on. He was hanging on that gun for a while. He had to, until he could go put it in evidence. So there's your other male DNA. So we're slowly building up to see evidence that may be helpful, that might not be helpful. And as we continue, then you hear from an Emily Curran. And she's talking about how she looks at the fingerprints, the palm prints, evidence collected, DNA, all that stuff collected. She takes it. She works with the lab. She gets things going. And she starts talking about the cartridge and the container. And as I jumped in there and finally said, we're just talking about a magazine. I mean, we're talking about a clip and bullets, right? I mean, you know, sometimes when we're dealing with doctors and the GBI and everybody else, they're a little smarter than us. They talk a little bit higher than us. But I wanted to make sure we knew what she was talking about. And that was the clip and the bullets in it. And she kind of said there was some that would be enough to test, and there was some of the stuff that wouldn't be enough to test. But why would you want to test the bullets and the clip? It's her gun. Who else is putting bullets and clip in her gun? But they never once mentioned about testing the trigger. We got DNA on the slide, that's good. But we don't know what's on the trigger. And maybe it was because they didn't get a big enough sample, or somebody didn't do their job right and get a sufficient sample for them to test. But we do know one thing. It wasn't tested. So we don't know who's the dominant, who's the minor, or who's is on the trigger. And from there, the witness, Miss Rosser. And Miss Rosser got up and she started talking about what she perceived happened. And I believe I showed her where everybody else was using this map to show where the roads are, where it all happened. And I'm not sure, maybe it was her parents. I mean, some people don't, recognize markers or where they were. But she started saying something was going on up here. Everybody else saying it's going on here. But she says it's going on up top. And she says that she was in a car by herself. She was looking at the ceiling. But she saw Miss Payne run to the car and try to conceal herself. Put a hoodie on. A bright pink hoodie. If somebody's trying to conceal themselves, they're not going to put a bright hoodie on. But she never once mentioned that her shirt was ripped and exposing herself. But she saw it all. She saw what happened, and she could testify. And her statement was, a white male came out of a vehicle that drove up behind him and then drove off once he saw the gun. If somebody's going to interject themselves in a situation like that, I don't think they'd wait for somebody to turn around. And I think they would have stopped it, or grabbing it, or stopping it, or somehow thwarting what was going on. But once again, I wasn't there. I can only go off what they're saying. And she said, you know what? This white guy walked in, he had somebody else in the car. He saw what was going on. She turned around, never pointed the gun at him, never got aggressive to him. But he said, oh, listen, enough for me. I'm out of here. This ain't worth it. So I asked her about the traffic. And she said, oh, it was clear. She said, I was in turning lane up here. I could see everything clear. You're in a turning lane on a busy highway. 2, that traffic is miserable, but she can see clear. So really, how bad was that traffic? Now, I know that the officer said he was there stopping people from going down 285, and everybody here knows how irritating it is when you need to get on the highway and they're stopping. You got to reroute you. So maybe there was some traffic there, but not enough to block her vision. Where she said she was right there, kind of side to side, looking at it. I think she said 10 yards. 10 yards. I don't know. I usually like to hear feet, but everybody has their preference. 10 yards from it. And she saw her gun out, holding at gunpoint. And blow. She didn't see it. She heard it. But knows. Blow. So did it happen in the car? Did it happen out of the car? From her testimony, I don't think you really understand, or I don't think you get a good impression of what happened and where it happened. But that's for y'all to decide. That's for y'all to take her testimony and compare it to the other witnesses. Because remember, they've had 4 years to get these witnesses together. And I asked the witnesses, did y'all talk to the media? I mean, why the difference in the story? Did you talk to somebody else? You talk to the media? You talk to the detectives? No. Yeah, I talked to the media. Yes, I talked to the detectives. And yes, I talked to Bonnie. And they're here giving testimony that's different from what they initially gave. And you, as the decider of facts, has got to decipher from the story that you heard from the first account, the story you heard from the second account. My opinion is, when you go back and you talk about what you heard, they're not going to measure. It's not going to be something that you can see or put together or say, yeah, this is kind of close, it's kind of not close. So I think we took a break there and we went on to day number 2. And day number 2, I believe it was...
We're only on day 2. We'll be here all day.
And she was here. She's a tough cookie. She turned to you when it was asked questions from the stage. She turned to you and was talking. Friendly. Explaining everything. And I kept asking her. Your report said the bullet went right to left. There's a slight downward angle. Right to left. That means if he was in the car and the gun was outside the car, it'd have gone left to right. Well, it depends on what the position of the driver was. When she wrote that report, there was a position in her head that she had that driver sitting at when she said it was right to left. And I asked as many times as I could before I was stopped to try to get an answer out of what position was that driver in. I don't think we ever heard it, but we all know that when she wrote that report, there was a position he was in that she came to the conclusion the bullet went right to left, a slight slope down. I asked her to draw me a picture of it. Show me if it goes in the body, because in her reports it talks about organs that it hit. She didn't want to run it. She didn't want to draw a line. She said, there's a dot here, there's a dot there. That's all I'm doing. So, usually you're dealing with forensic examiners. They're going to tell you everything that's going on. And she said, well, we can't really talk about diabetes because the body, when it begins, to rigor mortis begins and the process goes and the disease is there, it's going to eat up that sugar immediately. So we can't say one way or the other. But what really is the relevance? I mean, no one's coming here to testify what diabetes does or how it would affect you. So called speculation. And she goes and says no. And then I ask about the drug test. And she says, well, it's comprehensive. I understand comprehensive. Y'all understand comprehensive. But there were 5 specific drugs that were singled out. And in the report, it says, out of those 5 drugs, and it says specifically those 5 drugs, it was negative. Cocaine, opiates, benzo, nothing about amphetamines, nothing about other, as she said, common addictive drugs. But it's a comprehensive test. And we didn't get into that report about, was it a hair follicle? Was it blood? Was it urine? What was tested? How was it tested? We never got into it. So, as we say, it's comprehensive. That should be enough. That should be enough for y'all to believe there was no drugs in the system. The test was done 2 days after. So, she quickly gets off the stand and she goes. And then we have Cameron Williams, Cameron Williams. Nice guy, seemed personable. He gets up here and he talks about how, hey man, I videotaped it. And I'm watching it and I see a struggle. And as they're struggling, all of a sudden I hear a big, and it's a gunshot. And this gunshot goes off. And he goes, oh, hell no. So he's got a video. He gets out. He gets up right beside Miss Payne. And on the 911 tape, you hear her say, sir, did you see what happened? Can you stay here to tell what happened? And he didn't really respond. But you see him talking to the officers. I got to go. I don't want to be involved. I got to go. They said, you got a video. Could you give it to me? You give me your email address. You ain't getting it off my phone. I wouldn't want anybody to have my phone number either, so I'm not condemning for that, but I did notice that he wasn't going to send it to him from his phone. It was going to have to be an email. And you heard that his dad is law enforcement. And we don't know what his dad said to him. It would have been hearsay. But we don't know when the video was given. But we do know the state brought out that he had contacted her, mentioned he had a DUI, and wanted to know what she did. And she did the most professional thing you can do in her position. Ooh, I don't do misdemeanors. I can't help you on this. I don't want anything to taint this case. But it's never said when the video was turned over. And he's up here testifying. And then he gets up and he goes with the investigators to refresh his memory on the video. Because there's a interview with him that it's been a while. Then he goes off to refresh it. He comes back and pretty much says what he sees on the video, and you've seen it. I know a lot of people say, I've got to see it to believe it. I don't want to hear it, I want to see it. So you see it on the video. And he gives what he saw, and what he saw was there. A struggle, going back and forth, fighting over the gun, punching from both sides, struggling, going back and forth. I didn't see the gunshot, I didn't see where the gun was. There was a gunshot. Oh, by the way, she jumped out and grabbed the shell. She jumped out and grabbed the bullet shell. What is it, a sniper? I mean, nobody stands out there and picks up a bullet shell. Unless you're in the movies. Unless you're doing something wrong.
Unless you reload.
So why is that twisted in there? Why would it even be brought up? I showed him the picture of the phone, of her picking up the phone, a still shot. That shell must have been behind it. Must have been behind it. I don't know why that twist was put on there. But his testimony was pretty good. It was almost the same as what you saw in the video. Except for that one little biased twist of her picking up a shell. And we'd heard the examiners had come in between when he was stepped out to refresh his memory. And we got Lavoy that talks about the process it takes to get a palm print, to get DNA, and taking it and checking it against layman prints, and what the prints can tell you, and the alleles, and the finger, and the DNA, and how it all meshes together to say, hey, I'm positive this is that DNA and this is that DNA. But there wasn't sufficient palm print taken, or wasn't sufficient evidence brought in for her to conclusively say, I know whose DNA or I know whose fingerprints were here and there. But never tested the trigger. Never tested the trigger. Once again, they have their procedures and they have their orders. Never tested the trigger. If you can prove something beyond reasonable doubt, you test that trigger. But it was never tested. And then you have Cynthia Squin, I believe was her name. And she talks about the forensic biology. And she's the one that comes in and says, hey, I got something for you that's relevant. I got something that's important. There's DNA on that slide. There's DNA on that slide. Male DNA. And there's female DNA all around the gun. But there's DNA on the slide. And the key part there is later on when Officer Ritchie comes in and says that spent shell was stuck in the chambers. Was stuck in the chambers. It never came out. The shell never came out. Why? Logic would say that something was obstructing it. Something that when it pulled back, left DNA on it. But the shell never came out. So when he said that, I picked up the shell, and she picked up the shell, there's no way she picked up the shell. It was never discharged. So you have to take that story with a grain of salt. And then we continue to go through a bunch of pictures of what happened and where the cars were. And Detective Moore gets up there and says, hey, I was there. I interviewed, I talked to her. Yeah, I took pictures. And these pictures were taken at the very end. The interview at the very end. Didn't really want to take pictures unless somebody said, hey, I need pictures taken because she said she was scratched. She was grabbed. She was hit. She was bruised. And every account saying that she's pounding. Here, not a bruise, a scratch on, well, a pin top bruise on the left shoulder. That's all they could say. They never said any bruises, scratches, or anything else. But you saw the pictures of Miss Payne. Scratched on her head, on her arm, her wrist, swollen, her eye, swollen. Pictures may not have given the best representation, but we all know those bruises don't come until after a day or so. And Detective Moore says, okay, I took those pictures, and here they are. And I took out a ruler, and I measured those pictures so that we can have an accurate representation of what size and what scratches, and all these just little breaks or whatever, if it was a deep or cut or long. So that's all her testimony. And then you have Officer Ritchie. He shows up, the one that was there, the one that was doing the most. He shows up, he takes the gun from Miss Payne with no glove. He puts the gun down, he tries to assist. He can't get into that door on the driver's side. The door that Hayward kept saying, was it open, was it closed? Did you open it, did you close it? How could it be open? Were you trying to keep it shut? That door wasn't working. And Richie could not get into that door. And when I asked him was because of the accident or whatever, he goes, I'm not going to speak, I'm just going to tell you I couldn't get in the door. So he goes around. And he gets in there, and they're talking with Mr. Harry. Keep here, hang on. And they're getting the EMTs, they're getting him in the EMTs. And he's leaving, and he says, you know what? They're optimistic. They're in the EMTs, I've done my job. Kind of looks in the truck a little bit. Sees all this stuff in the truck, and y'all saw it in the pictures, and you heard testimony. There's a knife. There's a little saw. There's a cooler. And asked Detective Moore, what's in the cooler? Because if there was insulin in that vehicle, it must be cool. It must be kept at a cold temperature, and it would have been in that cooler. They didn't want to go and look into that cooler. They didn't want to completely say, you know, beyond a reasonable doubt, he was a diabetic because he's got all these needles and there's insulin. But they couldn't say that. It was not in the cooler. If it was, they'd been sitting there waiting, guess what we found? But there's nothing. And what they took as evidence from the vehicle to help in their investigation, what did they take? Nothing? It didn't appear like they wanted to find anything of use. They just looked it over, took pictures. And he sits there and he testifies to what he thought might be important, what he thought he might would collect, what he thought he might collect it for. And he said, but I didn't do it. There were other people who were doing it. He rattled off how many officers? 4 or 5? 4 or 5. Do we ever hear from those 4 or 5? No. No. We finished with that. We looked at his body cam. We see how everybody is standing around Miss Payne, talking to all the bystanders. You shot him. She shot him. You shot him. You shot him. She's standing there. No, my finger was not on the trigger. And they're having a conversation. They're not getting aggressive with each other. They're not jumping on them and beating them because they think somebody shot somebody. They're having a conversation, trying to figure out what's going on. That's civilized. That's what you're supposed to do. You're not supposed to take a side and just get aggressive or do something. But yet, says, here he is. The motive for tracking down, chasing down, and shooting Mr. Herring, because he's a bad driver. That trivial? A bad driver? If somebody had that kind of anger or something like that built inside them, they had issues on, they would have anger management, they had problems that would have been documented. Nothing's documented on this thing. She's not got a ticket, she's not in trouble anymore. So, you take all of these evidence, and that's the evidence. And then Miss Payne says, you know what, I want them to hear what happened. And I want them to hear it from my mindset, because everything you heard, it just didn't sound, it didn't sound, it wasn't meshing together. It wasn't, some of it wasn't possible. Some of it wasn't logical. Some of it was just common. But I don't want to take it away from them, but I try to be reasonable, because everyone can perceive something totally different than what really happened. We talked about that at the beginning. You can see the same thing happen. Two people have two opinions of it. But you have 4 years. 4 years. Take all these witnesses. Take everybody that talked to you. Everybody that saw it. And when you kind of put a few together that make sense or that are close to being exactly what happened, or close, but you didn't hear it. Did not hear it in the testimony of any of those witnesses. Miss Payne gets up there, and she's telling them what's going in her mind. Yes, I heard them say, don't chase. And I heard them say, be safe. The second time, I think I was talking, I didn't hear it. But you heard it 4 times. I didn't hear it 4 times. They told me to come back. They didn't say, don't chase. They said, come back. You need to. Both of y'all need to come back. And that's what she did. She pulled over, she had her phone out, and she said, I got the police on the phone and let them see 911 on her phone. You know how the phones on the screens, they had who you're talking to. And she walks up and she's like, I got the police. You need to come back. They want you to come back. Whack. That phone's gone. That's on the ground. But it's still got 911 on it. She's thinking, well, somebody's got to hear this. And grab. And then all of a sudden, you see her shirt. And you saw in the pictures. And you'll see in the pictures when you go back there, her shirt is being pulled in. And her testimony is, I didn't pull the gun in. I don't know what people say. She walked up with the gun on her. Now, a couple of them said it wasn't until the car hit her Jeep that the gun was pulled out. But she said, I didn't pull the gun out then. I'm sitting here trying to get away. I'm trying to move back. He caught me by surprise. Never been in a situation like that. It's up to God she'll never be in a situation like that again. Because no good deed goes unpunished. And she knows that now. But before then, she's a people person. She's trying to help somebody out. We're going to help them out in Payne County, the place she grew up in. A place that we've heard stories. We've seen incidents. We've seen the news. She graduated high school. She went straight to work. And she's been working the best she can at these apartment complex. Obviously, they've given her some quick responsibility because she's going up and picking up tills and showing properties by herself. And that's pretty scary for a 21-year-old. It's pretty scary for anybody. So she keeps that gun with her for protection. And she says, when I pulled it out, I thought it'd be a deterrent. I told her, hey buddy, I got a gun. You let go of me, let go of me, let go of me. Stop, stop, get the fuck out of this car. You can't drive this car anymore because it's gonna blow up, it's smoking. And if you're out of that car, you can't cause any more problems. You can't hurt anybody, you can't cause another accident. How'd that work out for her? She's being dragged into that vehicle. She's being dragged down the road, whether it be like an inch, or whether it be the size of this table, or what. When you're grabbed, if you're pulled into a hole and you don't know what the world's going on because he's going, I got something for you. I got something for you. And he's leaning back. She didn't try to say she saw something. She didn't try to say there was something in there that could hurt me. She told the truth. I don't know what was in there. I just know he was grabbing me. In my mind, I said, holy cow, what is going on? But I got the police on the phone. How's that going to help her? How's that going to help her? In theory, you would hope they're close by. You're going to be safe. In reality, it's not that safe. So he's grabbing her, he's pulling her, he's ripping her shirt, scratching her. She says, I got a gun and I will shoot you. Is that enough deterrent? Nope. So she pulls it out and she sits there and eventually gets pushed up on the car, and her testimony was her hands like this on the car. And she's trying to push back. And you look in the pictures and the video, she's on her tippy toes. And you got dirt on her knees where she's pulling back, trying to get away. And you see a still shot that the state entered that has her pulled back like this. But you can use common sense, and you can use, after hearing what happened, what would cause a hand to come back that quick? If it's being held and you finally get it away. And she said that's all she wanted to do was get away. That's all she wanted to do. And when she pulled that gun that she learned in training, when you pull it, if you mean to do harm, put your finger on that trigger. If you don't, you leave it up top. She didn't want to do any of that. She didn't get a chance to even think about it. She's trying to push off the car, and he grabs her. And you heard her testify. Grabs her right wrist and is trying to pull it back. And you see the swelling all over her wrist. And you saw the demonstrations I did with that gun. The way it was explained, the way it was told, the way the DNA showed that that top slide had DNA on it and a shell didn't eject. There's only one possibility on that. That hand was there just, obstructing that shell from being shot and shot out. And when you go and you put your hand on the top, the way he had her wrist, and you put your hand on the top, how many of my fingers went right into that trigger? One time it was 2. When I asked Detective Hayward, how many fingers were there? 3. 3 fingers, 3 opportunities to pull that trigger. And when I asked Detective Hayward, in your interview with her, right after it happened, 2 hours after she sat there, 2 hours, and you sat there, and she said, he turned, pulled the trigger, and I heard a click. I heard a click. Turned and pulled the trigger. Now he's a detective. He knows what the hell's going on when somebody pulls a trigger, pointing a gun at you. We didn't want him to speculate, but if a gun's pointed at somebody, and the trigger is pulled and it clicks, that's an aggravated assault. That's attempted murder. That's something right there that puts your life in jeopardy. Nobody wants their life in jeopardy. Nobody wanted to be in that situation. But by God, now it's increased even more because she's thinking, oh my God, he's going to kill me. And you hear her say, I had a grip on it, I didn't have a grip on it. I was trying to get it back there. My hand was under the trigger. No, it's a trigger guard. And they went back and corrected a couple of times, because sometimes she said my hand was on the trigger. My finger was on the trigger guard. My finger was on the trigger. In that kind of chaos, her hand is trying to push off. It's only natural to think your finger is going to stay with that gun as you're being twisted. If you're being twisted like this and it's on the trigger, you're not going to have those bruises on your arm. And how could it be if the hand's on top of it, turning at the angle it is? And remember the angle it is. He's sitting there in the truck. And it's being twisted right into his chest. It may have been at the angle that hurt, but in order to get to her, he's got to turn it around past him. And as he's doing that, he's got his fingers on the top, and they're going back and forth. State's got one theory, one option, that finger of his fang was on the trigger. As you heard and saw the demonstration, the man is grabbing that gun, twisting it, possibly has two, possibly has three fingers. In the trigger guard, on the trigger. That was never tested. So as you go back and you look at it and you listen, you review all the pictures and you hear all the evidence and you hear the judge say, the state's burden never changes. It's a burden, a heavy burden to prove, beyond a reasonable doubt. Okay? And she starts off with the presumption of innocence. So you got old lady justice here, and she's got the scales, and you've got the presumption of innocence. You're here. It takes a minute to get up here. There's got to be some good evidence to get you even close to being even. And then you got to prove beyond a reasonable doubt that one theory, that her finger was on that trigger and shot him, is the only theory you can come up with. And they proved it beyond proved it. They proved that he had diabetes, and I don't know where that's going. But by the sister saying he had it, they proved it. By saying that detectives twisted her story up, but then kept coming back and correcting it, that she had a finger on the trigger the whole time. When you heard the struggle, you saw the positioning, there's no way it occurred. And you've got to believe that that one theory is the only plausible theory that occurred. But you saw in the demonstration, there's three, possibly two, hell, possibly four other theories that when he grabbed that gun, how that trigger went off. And that trigger went off while this young lady is sitting there, scared, out of her mind, never been in a situation before. Here's somebody, I got something for you. Leaning back, getting the trigger, and pow, click. Shoot. He pulled the trigger. You heard the click. And they didn't seem that was important. That basically, when it comes down,
here comes an objection,
trial,
I think.
as I said, verdict is an individual honestly seeking the truth of what happened.
Oh, he avoided it.
And I stated that to
He's
the
flirting
prosecution.
with this.
Verdict means seeking a conviction. Seeking a conviction. So they come in here with boxes. And they got these boxes. And they only want you to see what's in this box. Because if you see only what's in that box, you may see it the same way they did. So my job was to get as much evidence out as I could. And I tried, you saw I fought it a little harder than I should sometimes, but I wanted to make sure you saw everything. And I believe that you have enough knowledge, intelligence to see really what was going on. And I told you that no matter what happened, I want to get all this evidence out there, so when you make your decision, you can look the state in the eyes, and you look Miss Payne in the eyes. You can look at it and say, you know what? I hate to say it, Steve, but you didn't prove this beyond a reasonable doubt. The judge told me, when I look at it, I need to look at these factors, follow this law, and they must prove it beyond a reasonable doubt. And they didn't. They didn't put up enough evidence. They didn't show beyond a reasonable doubt that certain things happen and that certain things, there's no other theory. But with the evidence we were able to squeeze out, we gave you those theories. We gave you as much evidence to see the whole picture.
Phil, don't do it, man. Don't do it. Resist the
You
urge.
see that whole picture, and you go back and you go through all the pictures, and you go through your recollection of what the witness said, what the theories are. You're going to come back. And you're going to go back and say, you know what? I'm not supposed to listen to that attorney, but it made a good point. State didn't carry the burden. And I don't think I can sit there and look one person, one side, in the eye, and say that it was fair and I did it from the evidence given there. But you've heard it, you've seen it. I don't want to take more of your time. I know that after lunch y'all are about to fall asleep. But I hope that you look at this carefully and come to the same conclusion that we've been saying for 4 years. If you hear all the evidence and you see it all, this is not some killer. This is not some murder. This is a young girl that got caught up in the wrong situation with a good heart and good intention. And when she did it, her mind was not to confront, not to get in arguments, not to pull a gun, but to get the man just to go back. We don't know why he didn't go back. She didn't know why he didn't go back, but she sure as heck didn't think it was going to end that way. So, as you go back there, look at all the evidence. I feel comfortable you've seen enough. You've got enough information, enough understanding, enough experience to see really what happened. And the audacity of the state to say that you're going to find her guilty from the information they gave.
He says audacity.
I think different. I greatly appreciate your time. And I know it was a lot of time in the week, and I know y'all didn't expect that. But I appreciate it because I've seen you be attentive. I've seen you been listening. And I've seen those eyes wanting to seek the truth. And I hope you've sought enough truth so that you understand it didn't happen that way. It didn't happen, and even with the theory they have, there's still 3 other plausible theories of what happened. It comes down to they just didn't present a case. It's beyond a reasonable doubt to convince you that Miss Payne is a murderer. Somebody just called you because she didn't like the bad driving. He's a bad driver. You heard the one girl up there, boy. She said she didn't crazy bitch. She would not change her mind.
He's got all his papers, but he got a second wind.
You never once heard her say, "Ooh, this guy's crazy. I think he's inebriated," but that's it. So I leave it to you, and I implore you to go back, look at the evidence, and do the right thing. And I appreciate your time, and I appreciate your attentiveness. And I appreciate when you come back and find her not guilty of all 8 of these charges, these heinous charges they put against her. Thank you so much.
That was, he had to sort of wing it because he didn't have his PowerPoint.
At this time, before the state makes its closing arguments, I'm just going to give the jurors a 5-minute break. It's now 3:05. I'm going to give you till 3:10, and you'll come back in and the state can make its closing arguments.
Who had extra bonus break on their bingo card? Because we just got another bonus break. Another break, probably because the jurors were sleeping. Now, I'll say this. The defense attorney, he gave it his best. He gave it a good go. But it still just doesn't unless he pounds the table again, bam! That's when he hears the gunshot in the video. That's the only moment that really made me want to go, what did I miss? Maybe it's just the way he speaks. It's soothing. That southern drawl, it just gets me to my happy place, I guess, and then I go to sleep.
Call from Mr. Wisconsin.
Mr. Wisconsin, how are you doing today? I haven't know what's happening.
Hey, how are you? So, are you ready? So, did you get my message about the Guatemalan Cessna? Is that who picking you up? Are we ready?
I've turned down all your offers for contacts who offer rides to sort of provide legal justification for their cargo. No, I'm not gonna fall for this trap.
It's not a trap. You just don't look in the envelope. You hand it to a guy named Juan, and everybody goes home safe.
Nope.
Like everything works out.
Not going to happen.
I'm glad you're going down there.
I would sooner do Greyhound bus, which I'm not a fan of.
You know what? You know what I did not appreciate when you said they still have Greyhound buses? That was the most elitist thing I had ever heard you say, Hooray. What do you mean, do they still have Greyhound buses? There are millions of hardworking Americans taking that Greyhound every single day, okay? Like, for goodness sake, do we still have them?
Let me say this: maybe I'm elite. Okay, I grew up poor. The bus was not an option. Okay, just for your story, we had one family car. It was a 1976 Ford Country Squire station wagon with fake wood paneling, with studded snow tires.
Oh, you had a Woody. Did you used to hit people when they said Woody? Did you
no,
give them the
no. That's what I got to drive to high school. This is my growing up. Okay, we grew up poor. We could not afford the Greyhound bus. I also grew up without a television, so unless I personally observed it, it didn't happen in my youth. Okay. So here's what I did observe: the casino buses on the weekends. That was the thing. I thought that's what you were talking about originally when you said ride the bus. I'm like, well, I'm not going to the casino.
No, that's just full of old boomers that are looking to sit at the slot machine for 15 hours and get a free ride back. That's what the casino buses are. And boy, do I love them. Because you could sit out there with a $10 fake voucher. Never mind. Keep going.
Anyway, good stuff. We don't have to fight about buses, Ivan. We have other fun things we can fight about.
So, yes. And so anyway, you're heading down there, right? You're heading down there?
Yes, headed down to Florida. It's going to be a drive. I'm going on my own. It's going to be nice, me, quiet, my thoughts. And maybe I think I'm going to take the 12-disc box set interrogation video from the Border Patrol trial. I should be able to get through most of those on the way down.
I think you should just put a zip file of everything I've ever recorded and re-listen to it and then learn from that. Like, I think it could be a good learning experience. Like, it could be like a tutorial.
Do you know what road rage looks like?
I think we're finding out in this trial.
That's funny. No, I'm really. We're super excited. There've been some really generous people who've contributed to make things possible, and it's going to work. We're getting a hotel. We're going to drive down. We're going to stay the night. We're going to live stream from the courthouse with our fingers crossed if everything goes well, because there's one piece that depends on another party, and if they choose not to do something, it causes a problem for all of us. But as long as everything works well, we're going to live stream from there, and everyone will be able to watch on this channel. So that's the goal.
Hey, brother, safe travel. I just talked to my 80-year-old pops, and I finally played him the whole birthday serenading. He wasn't impressed with the Russian, but he did appreciate the effort. And so he said, you know what he said to me today?
What's
he
that?
Said he's not going to send Christmas presents until I show him proof that I have showed my 15-year-old son and 3-year-old son. Notice he doesn't include the daughters because he's Russian. But he said, as long as I won't send their Christmas presents until I have proof that you have showed them both Patton and It's a Wonderful Life. Now, It's a Wonderful Life, everybody...
Is Patton a Christmas movie?
It is if you're Russian, okay? And so... don't ask me how, don't ask me why, but that's how I was raised. So I have to somehow sit a 3. He'll be 4 in March, but I have to somehow sit a 4-year-old down. And have you ever watched Patton?
No.
Okay, do you know how long that movie is?
No.
Wait a minute.
I imagine it's like watching Dune on repeat.
Now you're out of the family. Like
okay.
My dad would.
No Christmas gifts from me.
My dad said, I will not send the presents until I have proof that you have showed the 3 and 15-year-old Patton full length. So I have to. Has anybody ever seen Patton except for me? Like, there's got to be people in the chat. Do you know how long the movie is? It's 3 discs on the old discs. Okay, so like, it's a good 6 to 8 hours. Okay, now don't get me wrong. 2 of my children, and I was talking about this with somebody in chat. Like that scene where Patton is like Nobody ever won a war.
How did we get
for
here?
his country.
Ivan, how did we get here? I thought for sure we were going to talk about like defense closing and the strong points and what just resonated with you and completely changed your mind and convinced you that Hannah should be a free woman for the remainder of her life. I thought for sure that's what was going to come out of your mouth.
You got to be lying. You're lying.
I know you're not on that page. I'm not as well. I tell you.
Really?
I fought at the beginning. I fought hard to stay as impartial as I could, and what I did is I pointed out every time the prosecution brought a witness up to the stand and said, they testify and it didn't match up the evidence. I'm like, you can't believe them. You can't believe them because it doesn't match up to the video. And then we got Hannah on the stand, and she has the same thing. She has different versions that conflict, and so now I'm left with not believing either. Maybe that means I still have room for reasonable doubt. But
no. That just means your conscience is taking over. That little thing that like sucks. Like when you want that's what's taking over, because even you, like I said all along, I said all these semantics about what happened in that split second in the car, or who pulled trigger or who fought. None of that's going to matter to the jury. People can crucify me over that on whether that should matter or shouldn't, but none of that's going to matter. What's going to matter to the jury, as we have seen time and time again, is the events leading up to, and then what occurred after is sort of, I hate to say this word, collateral damage. Because if Hannah listens to 911, this man's alive.
Yeah.
And I think that's how, whether it's legally right or not, whether that fits within the jury instructions or not, that's what the jury's going to think. Because guess what? The jury are humans with regular jobs. They're electricians. They're plumbers. They own liquor stores. You have YouTube channels. They're just regular people. They're not true crime freaks that listen to every single word and like get hung up on it.
Hang on, okay? Freaks. Where do freaks come from?
Well, we are true crime freaks. That's what we are. Okay, let's call it what we are. But they're not going to get hung up on these little semantics about like what happened, why was her shirt ripped, and what was the angle of her elbow. Nobody's going to care about that on the jury. They're going to say, why did this Annie Oakley show up and decide to play cop when she wasn't and was directed not to? That's what they're going to see.
I think we're on the same page. I think we both agree what the jury's going to do. I don't know if they're going to use the same reasoning, but I think they're going to get to the same conclusion. I think they're going to throw the book at her. That's what I think is going to happen. I struggle with that personally myself, because there's so many points in there. I mean, you talk about excited utterance. You talk about in the moment. You basically have the state saying that, according to one of the witnesses, that she had thought this out so far in advance that she was going to pick up the shell casing and put it back in the gun to show that there was a struggle over the. This is bizarre. Okay, some of the evidence, the testimony we've heard from the state's witnesses is just bizarre, and to me that is not reasonable. That is not reasonable.
Yeah, right.
But there were so many times where her tone of voice, her excitement level, was the fact that she was calm. She's like, ma'am, this guy's going to cause an accident. I'm just going to stay here until the police can catch up. The fact that she immediately, says you need an ambulance. There were so many times that I think that her intent was good. Okay. Does that mean she didn't break the law? No. I think she did break the law. But her intent was good, and it's hard for me to find malice murder in that.
There's some old terrible, what is that road to hell paved with? Good what?
Intentions. Intentions. Good intentions.
Okay. And so I don't think anybody on that jury is going to care about that last 6 seconds that happened where who reached for what, and like he has a right to defend himself if some crazy Annie Oakley is coming up to his car with a gun drawn for no reason, for a car accident, even if it is drunk driving. I don't care if I hit a semi-trailer I don't care if I hit a school bus. You don't get to run up on my car with a gun screaming orders at me. Who are you? You know what I mean?
I will tell you, I don't believe that happened. I don't believe that she ran up to the car with a gun drawn. I don't believe that she ran up to the car with the gun displayed. I think she did run up to the car with her phone, because the audio seems to match up that one. Ivan, we've got another call coming in. Thank you, my friend. It's always good to talk to you, even though you're wrong most of the time. Just kidding.
Come on. At least 50-50.
50-50.
At least 50-50.
Thanks, Ivan. We'll catch you later. Bye. And I cut him off.
From
Corporal USMC retired.
Corporal USMC retired. Good to hear from you again. How are you doing today?
Hey, I'm doing all right. How about you?
Good.
So the point I can't get to is, at what point did she break the law? I mean, that's what I have to consider. It's not illegal to disregard what 911 says. It's not illegal to follow somebody. You know, did she break the law by getting out and approaching the car? Well, no. So if she was banging on the door and reaching in and grabbed him, then yes.
In reading, I've been reading, and I haven't been talking about this on air, but I've been reading Georgia law quite a bit, trying to read between the lines and understand in that state how the laws apply. And I think she broke the law because she was not faced with lethal force, which is a requirement for her to use lethal force against him. She has said she didn't see any weapon. She didn't say there was he was reaching for the drywall knife or something. Her testimony. I mean, if she was in the car and they were driving and she was being dragged, that makes sense. But that's not the story she told the police the day of. She said she wasn't in the car. As a matter of fact, she said she had to rack the gun, meaning that she had both hands free at the time. Like step back. I believe that
she said he had her by the shirt when she racked the gun.
But the shirt tore, right?
Yeah, but I don't think she ever said that she was completely free of him, did she?
I might be wrong on that. So I'll back up on that one. But I didn't see. I see that she is so close to being in the right. Really, very, very close to being in the right. But I don't see.
Yeah, in order to pull a gun, you just have to be in fear of great bodily harm. And I don't think if a guy is pulling at you and trying to pull you into his vehicle that's filled with a bunch of tools, I don't think it's a stretch to say that you're in reasonable fear. Now, do I think she behaved recklessly? Like, as you look at the whole picture, absolutely. I think she could have done 100 things differently, but I don't know if I can't get to malice. I mean, if you look at the different cases that are actually malice murder, like running after somebody, stabbing them, chasing them down, I don't think this reaches to that conclusion.
Yeah, I don't know. For me, I don't think I didn't see the threat to her great bodily harm. Oh man. In that moment, I think that was a problem. I think the her racking the gun and the judge is coming back, so we're gonna have to cut this back. USMC, yep. I appreciate your wisdom in this. You're obviously educated on this topic. We'll have to have a discussion when we have more time sometime. But
yep, sounds good.
Thank you, my friend. Appreciate the calls. We'll see you.
Yep, bye.
Bye. The Brown Barn says, 8 months of loving you all. Thanks, Recovery Addict, for introducing me to this great new world, and Reverend Beasy for showing me how to share this. Thank you, the Brown Barn. Appreciate you as well. Man, I hear what USMC is saying. At what point did she commit the crime? And those are words that I was saying as well early on in the trial. It wasn't in following him. That was wrong. I mean, that was wrong from that's a dangerous thing to do. The police told you not to do it. That was wrong, but that's not against the law. That wasn't the crime. It wasn't from approaching him with the phone, but possibly when she, at that point, said, get out of the effing car. Does she have authority to order him out of the car? He stopped at the moment. He stopped. Does she have authority? And then, is she instigated at that point? And then it escalates. It doesn't. You don't have to start out using deadly force for the other person to be able to use deadly force back against you. It can start off with words, and then a push, and then a shove, and then a punch is thrown, and next thing you know, you're breaking bottles, and that escalated quickly, and you've got the whole scene from Anchorman happening. Let's see. Tally says, you're chatting with Ivan. I missed my question. Do we believe this jury is also from a bus stop? Because that's the real question here. I believe they have a good representation jury, representative of the area, which is what it should be. It should be somebody who's familiar. This is their home as well, and that's it. And all we know is that the both sides asked questions, had the opportunity to exclude jurors. And they ended up seating this jury where they both felt that this was okay, that they had the people they needed to hear the case to reach the conclusion that would be right. Jermaine Down says, according to Georgia law, malice can't be formed in an instant. Can be formed in an instant. Yes, sorry, I said can't. And I'm like, wait, that's wrong. Yes, it doesn't have to exist very long. But it basically has to mean, I mean to do this. I'm going to cause harm to you. I'm going to do this. And it's quick. It can be very quick. Brandishing a weapon. Let's see. There's a relatively fine line between utilizing a weapon for self-protection and brandishing a weapon. Brandishing a weapon is a crime, a felony, aggravated assault. See, some Georgia legislators continue to work on modifying existing self-defense laws. A law that's in the books or in the works right now would make it legal for a gun owner to pull or show their firearm during a dispute as long as he or she doesn't aim it offensively at someone. But that bill was not passed back in 2020 when that was considered. That's interesting because if you study the concealed weapon stats, when a firearm is used in self-defense, 75% of the time it's not fired. So 3/4 of the time a firearm is used in self-defense. And USMC, if that number's off a little bit, please correct me in chat. But that's when I went through training, that's what I was taught, that 3/4 of the time a gun used in self-defense has not been fired. But you're still not allowed to pull it unless you mean to or you have justification to. Had a little sidebar there. I think we're ready to begin now.
So during our bench conference, it was brought to the court's attention that certain personal information. Okay, can you all hear me? Are you able to hear me? Okay. Personal information that was on one of the interviews was disseminated by the media, and as we heard earlier this week, once the personal information is put out, then there are people that make calls that are,
that's why we muted it.
Aggravating, annoying, not positive. And so I would just kindly ask the media at this time not to republish any information that's personal to the defendant or to any other witnesses in this case, so as to avoid calls being made that are not wanted.
And let me just say,
okay.
Don't make those calls.
Is
Don't be that
ready
person.
To proceed with it.
If somebody does share something inappropriately, don't be the person that makes that call.
Bailiff Ennis, please bring the jurors in.
That being said, I'm just thinking ahead to Friday. Friday, I will not have the ability to selectively mute. That'll be tricky. It's going to be really tricky.
You may be seated. The state will now give its closing argument.
I mean, not that it has anything to do with it, but my entire life until I was 18 and my grandfather passed away, I was going to be a police officer. And on May 7, 2019, she got her opportunity. And as a result, 62-year-old Kenneth Herring, who was unarmed and minding his own business, was chased down, detained, shot, and murdered by this defendant. And how do we know she shot him? Because we watched Officer Rich's body cam. And when he asked, who shot Mr. Herring? She said, I did. And you don't get the death penalty for committing a traffic infraction. And you know how much entitlement you have to chase somebody down, detain them, jump out your car, and run toward a stranger. He didn't know her. He didn't know why she was approaching his car, and demand that they do anything. He didn't have to listen to her. He didn't have to do anything she said. As he continued to ask her, "Who are you?" And the audacity to come here and take that stand and blame everybody else. Now, before I jump into all the facts and all the evidence that you heard today, I want to talk a little bit about what your duties are. You're to be a fair and impartial juror, honestly seeking the truth. And the purpose of the jury trial system is to seek the truth. Not to seek doubt, it's to seek the truth. You have a duty to follow the law, and you are bound by the instructions and the law given to you by the judge. Now, you shouldn't consider anything that's outside this circle. Passion, public opinion, dislike of the police, any sentiment, sentencing, prejudice, penalty and punishment, conjecture, whether you disagree with the law or if you have any sympathy for the defendant. The only thing you should consider is the law, the elements of the crime that I'm going to discuss with you, any testimony that you heard during this trial, any expert testimony, and you will determine the credibility of the witnesses, any photos, any audio, any videos that you saw, the physical evidence, and your common sense. We don't ask that you leave your common sense at the door, and any corroboration. Now, you do have a duty to deliberate. And if a juror refuses to deliberate or discuss with the other jurors the evidence or the law, you may bring this to the attention of the judge. Now, let's talk about some legal principles. Now, you heard a lot about the presumption of innocence. Now, the presumption only exists until it is overcome by the evidence. So once you believe the defendant committed the offenses as alleged in the indictment beyond a reasonable doubt, the presumption is gone. Now, the state does have the burden to prove every material allegation in the indictment beyond a reasonable doubt. And we take that burden very seriously. Now, let's talk about reasonable doubt. Reasonable doubt is not proof to a mathematical certainty or proof beyond all doubt or absolute certainty. There's no number. It is beyond the doubt of a fair-minded, impartial juror honestly seeking the truth. And it is based on common sense and reason. Now, there are two types of evidence. You have direct evidence and circumstantial evidence. Direct evidence points immediately to the question at issue. So, for example, any witnesses that testified based on things they saw, things they heard, things they smelled, tasted, anything of that nature. That's direct evidence. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may infer other related or connected facts that are reasonable and justified in light of your experience. For example, the DNA information that was presented to you when you learned that the major contributor on that firearm was a female and it was identified as the defendant. Now, the law does not favor one type of evidence over the other, so it is up to you how you weigh that evidence.
Is she actually reading a PowerPoint? Because that is the least effective message.
You may consider the personal credibility of any witness that took the stand. And it may have been shown in your presence, in their presence and by the evidence. So this applies to the defendant as well. What was their demeanor? Did they have any reason to lie? Did the facts they testified to match the evidence? Was there any corroboration? And is what they say believable? Now, we presented several eyewitness We presented several eyewitnesses that Attorney Tucker discussed. And you heard direct evidence based on things they saw and what they observed on May 7, 2019. Now, even though Attorney Tucker tried to twist their words, misquote their statements, they all stood firm in what they saw. And what was consistent between Ms. McCraney, Ms. Rosser, Ms. Jackson, and Mr. Williams was that there was only one aggressor on May 7, 2019. And that was the defendant. Now, you heard testimony from the defendant yesterday. And, you know, she stated that she never heard 911 tell her to not chase. And then when I went through her testimony and the transcript of the 911 call, they told her 4 different times, either twice to go back to the incident location. And they told her not to follow him. But she said based on her perception and what she believed they meant was that she should follow him as long as she remained safe. Now, it is for you to decide whether there is a reasonable explanation for any inconsistency in the witness's pretrial statements and testimony when compared to the same witness's trial testimony. You are to consider all the facts and circumstances of any prior statements. You, the jury, must apply your common sense and your reason to decide what testimony you believe or do not believe. Now, it's not a memory contest. These events happened nearly 4 years ago. And the witnesses got on the stand and they testified to what they remembered that happened on May 7, 2019. And for the most part, they gave you everything. Now you can imagine, you know, if you went to a wedding and, you know, you went to the wedding, you told your mother, you know, the bride's dress was beautiful, the food was good, and you told your dad, you know, they had a great open bar. The DJ was real nice. And you told your friend, you know, the invitations that we received, they were just beautiful. Now, you may not have told each one of them all the details, or specific details of what happened at the wedding, but what was consistent amongst the story is that what? I went to a wedding. And all of the witnesses were very consistent. That on May 7, 2019, Tiana McCraney advised you that she observed the defendant travel around Mr. Herring's vehicle and block him in. She stated that the traffic on that day was very congested on Riverdale Road. It wasn't moving. And when I asked her, was there any way after she blocked his vehicle in and detained him, could he get around her? Could he move in any way? And she said no. And what she also observed was the defendant jump out of her vehicle, irate and aggressive, and immediately run toward Mr. Herring's vehicle, screaming and yelling for him to get out of the car and cursing at him. Now, when you watch the defendant's interview, she never mentions to the detectives at any point in time that she yelled at him, that she screamed at him, and that she demanded that he get out of the vehicle.
Guys, let's be respectful of everybody.
Her characterization was, I walked up to the car, I held the phone, and I said, I have 911 on the phone, and they want you to go back to the scene. And that all of a sudden, you know, the victim just became very irate, grabbing her and pulling her into the car. And that's not what any of the witnesses saw. And you also heard from Ms. Rosser, who advised that she saw the defendant outside of Mr. Herring's vehicle punching him, being very aggressive, screaming and yelling. And you also heard from Ms. Jackson, who notified you that as she was leaving work and she made a left onto Forest Parkway, that she noticed the defendant's Jeep come flying down Forest Parkway, almost running her off the road, and other vehicles off the road, swerving in and out of traffic, which is ironic because she stated the only reason she was trying to get Mr. Herring pulled over because he was going to harm other drivers on the road. She wanted other people to be safe. And then when she caught up to Riverdale Road, Miss Jackson got up to Riverdale Road, she noticed that the defendant here, had caused an accident. She didn't know that she had cut Mr. Herring off and pulled in front of him. But what she did know was that she just observed her driving very irately. And so she pulled over because she was interested in seeing what happened. And what she saw was the defendant very aggressively banging on what she thought was Mr. Herring's window. But then what she realized was that she was actually punching him inside of the vehicle. And what Miss Rosser and Miss Jackson remember was her pulling that firearm. And when she pulled the firearm, she pointed the firearm in the vehicle. And what they recall is that she immediately shot. Now, the testimony of a single witness, if believed, is sufficient to establish a fact. So if you believe Tiana McCraney and you believe that she observed the defendant pull around Mr. Herring's vehicle and block him in, detaining him, then that's sufficient to establish that fact. Now, the law provides that criminal action shall be tried in the county where the crime was committed. And we did submit to you that this occurred on Riverdale Road and Forest Parkway, which is located in Clayton County, Georgia. Now let's talk about the charges. And this is where we will get into details about the facts and the evidence that was presented to you. The defendant is charged in count 1 with malice murder, count 2, felony murder, count 3, aggravated assault, count 4, felony murder, count 5, false imprisonment, and count 6 through 8, possession of a firearm during the commission of a felony. Now, I know there was only one death in this case, and we've charged 3 counts of murder. Now, the state of Georgia allows us to charge murder in various ways. And you don't have to pick one. If you believe that the state has presented sufficient evidence to prove that she committed counts 1, count 2, and count 4 beyond a reasonable doubt, you can enter a verdict on all of those counts. You don't have to choose one. Now let's talk about malice murder. Malice murder is when a person with malice aforethought unlawfully causes the death of another human being. Now, what is malice? Malice is the unlawful intention to kill without justification, excuse, or mitigation. Its malicious intent can be formed in a moment, so it doesn't require premeditation. It can be formed in a moment, and it does not require ill will or hatred towards another. An intent may be shown in many ways. It can be inferred from the proven circumstances or by acts and conduct, or it may be inferred when it is the natural and necessary consequence of the act. So if you pull out a gun and point it at somebody, then you fire that firearm, then the natural and necessary consequence is that they may die. Now, we believe we submitted to you that the defendant acted with malice when she chased Mr. Herring's vehicle in her Jeep. She cut off Mr. Herring's vehicle with her Jeep on Riverdale Road, cornering him in, blocking his ability to move, detaining him. When she jumped out of her Jeep in an aggressive manner, immediately runs up to Mr. Herring's driver's side door, screaming, cursing, and demanding him to get out the car, motherfucker. She tells Mr. Herring that she will shoot him. She draws her firearm from her waist. She wraps the slide with 2 hands, and she shoots him. And you heard on the 911 call, you heard her say, "You hit my car." And she says that right before she shoots. Now, she's also charged with felony murder. Now, when a person, while committing a felony, causes the death of another human being, irrespective of malice, so aggravated assault, which is a felony, plus a death caused during the aggravated assault equals felony murder. So there's no intent to kill. Intent to kill for this count is irrelevant. It's not required. So a person commits an aggravated assault when she assaults another person with a deadly weapon. And no injury is required for you to find the defendant guilty on this count. And what is an assault? An assault is when a person attempts to cause a violent injury to the victim or intentionally commits an act that places the victim in reasonable fear of immediately receiving a violent injury. And a deadly weapon, a firearm, when used the way a firearm is ordinarily used, is a deadly weapon, and that's as a matter of law. Now, the evidence that we submitted to you for the felony murder charge for aggravated assault is the defendant pointing a firearm at Mr. Herring, placing him in reasonable fear of receiving a violent injury. And as a result, shooting Mr. Herring, causing a gunshot wound to his abdomen, which the medical examiner told you caused his death. So in the commission of committing an aggravated assault, Mr. Herring died. Felony murder. Intent not required.
Guys, we've got some strong feelings in chat, and that's okay. Ooh. Is that a distorted view?
And we know the defendant committed an aggravated assault because you watched the video.
Oh, that was harsh.
And you watched her in this video shoot Mr. Herring. Now, when the defendant pulls a firearm and she pointed it at Mr. Herring,
just be nice to each other,
then
kids.
He reasonably believed in that moment that he would receive a serious injury. And therefore, the aggravated assault was complete. In count 4, she's charged with felony murder for the crime and felony of false imprisonment. Once again, intent to kill for this count is irrelevant. And a person commits false imprisonment when she, in violation of the personal liberty of another, unlawfully detains another without legal authority. And false imprisonment is a felony. Now, if you recall, when the defendant was on the stand yesterday, she did not want to state that she blocked Mr. Herring's vehicle in. But this is what you see in this photo. And that's what you heard on her interview, when she said, "I found an opportunity and I pulled in front of him and I stopped him." So once she blocked his vehicle in and blocked his access, blocked his movement, the false imprisonment was complete. She had no legal authority to do this. She's not post-certified. She's not a police officer. She has no arrest powers. Nobody legally told her to stop Mr. Herring's vehicle. And you heard a lot of talk from the defense attorney that he could have jumped up the curb and drove down the sidewalk. There was no duty for Mr. Herring to retreat. And as you heard Ms. Jackson say, who drives on sidewalks? So the felony murder in count 4 was complete when the defendant cornered him, restricted his movement, detained him without any legal authority. And during that false imprisonment, he was shot by the defendant, again causing a gunshot wound to his abdomen, which caused his death. False imprisonment was complete. Felony murder. Now, count 6 through 8 in possession of a firearm in the commission of a felony is when a person unlawfully has on his person a firearm while committing a felony. And we submit to you that in the commission of the false imprisonment, in the commission of the aggravated assault, and in the commission of the malice murder, the defendant was in possession with the firearm. And you saw that in the photo. Murder is a felony, aggravated assault is a felony, and false imprisonment is a felony. Now, this is one of the most important parts to remember as you deliberate. A person is justified in using deadly force which is intended or likely to cause death or great bodily harm, only if she reasonably believes that such force is necessary to prevent death or great bodily injury to herself or a third person, or to prevent the commission of a forcible felony. Reasonable belief doesn't just mean whether the defendant believed it. The question is whether it was reasonable for her to believe it. Would a reasonable person believe it under the circumstances that you've heard in this case? Was it necessary? To be entitled to self-defense, the defendant must have needed to use this force to protect herself from an imminent threat of death or serious bodily injury or a forcible felony. The problem here is that a person is not justified in using force in self-defense if she is the initial aggressor. The defendant was the initial aggressor and therefore is not entitled to self-defense. So, whatever Mr. Herring did, once the defendant cornered him, aggressively approached his vehicle, and pulled out that firearm, doesn't matter. He was within every right he had to do whatever he did to defend himself. Because there was only one person on May 7, 2019 that was entitled to defend themselves, and it wasn't the defendant. Once again, the defendant is not justified in threatening or using force if she provokes the threat or use of force against him or herself, intending to use that threat or force as an excuse to harm the other person, is committing a felony. False imprisonment is a felony. So, once the false imprisonment was complete, when she blocked his vehicle and blocked his access, she was committing a felony. And if you are committing a felony, you are not entitled to self-defense. And once again, if you are the initial aggressor, unless she withdraws from the encounter and clearly communicates to the other person her intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. To allow an armed aggressor who confronts an unarmed, non-threatening victim to claim self-defense when the victim struggles to disarm the aggressor is contrary to common sense and contrary to law. On May 7, 2019, you heard testimony from Terry Robinson. There was an initial accident that occurred on Clark Howell. You heard testimony that accident did not involve this defendant. She had made no contact with the defendant. There was no argument with her and the defendant. Her vehicle was not struck. that accident had nothing to do with her. She didn't get close enough, she stated, to smell any alcohol or the odor of alcohol in his breath. She just interjected herself in a situation that had nothing to do with her. Now, what she wants you to believe is that when Terry Robinson was speaking in the background and he said, go, 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 that meant for her to jump in her car, chase down Mr. Herring, block his car off, apprehend him, and detain him. And we know that's simply not true. Because what you hear on the 911 call with Mr. Robinson, the only thing he says, and the only thing he said was, take a picture of the tag. Now, if we are to believe that take a picture of the tag means this, and you also heard from Terry Robinson that the defendant was already in her vehicle. She was already in motion. She was already prepared to do what she felt she was supposed to do in this situation. And then you hear the 911 call. And you hear the 911 operator tell her, once they realize she's chasing Mr. Herring, ma'am, we advise that you do not chase or follow. And she said she understood 100%. But yet she still continued. And you heard testimony from Ashley Jackson that she was speeding down Forest Parkway so fast, weaving in and out of traffic. I mean, she is chasing Mr. Herring, almost causing accidents, almost running other people off the road. And you heard the defendant say, and when I finally caught up to him, I had an opportunity. Because in her mind, she was going to stop that vehicle by any means necessary. And she did. And it's unfortunate for Mr. Herring. And you also heard testimony of the rage she had, how angry she was, how aggressive she was. But when she stood on the stand, when she got on the stand yesterday, everything was so calm. And when her attorney is asking her questions, she has every answer detailed, laid out, how she was just a people person. She was just trying to do things to help. She wanted to help all the other drivers on the road. And when I was asking her questions, she became very combative and aggressive. And it was always my perspective, what I thought. No, the 911 officer, our dispatcher did not tell me to not follow, not chase. Because she knows best.
I didn't see her being as combative and aggressive as she's describing here.
And at the end of that 911 call, after she shot Mr. Herring, her whole attitude, I'm safe, but he ain't. But she wants you to believe that she was concerned and she wanted an ambulance and she wanted to assist and she wanted to help and make sure he was okay. She didn't care about Mr. Herring. The defendant had multiple opportunities to do something else. To go back to the incident location. To go back home. Not pursue. This had nothing to do with her. And the idea that she could command somebody to do anything. The only person that introduced a deadly weapon in this situation was the defendant. And but for her introducing that firearm, Mr. Herring would still be here today. You can't poke a bear and then when the bear turns around and attack you, want to claim self-defense. It doesn't work that way. She should have minded her own business. Now, this is the real reason we're here today. Now, the law doesn't allow us to talk about Mr. Herring's background and history and go into details about that. But there is no reason, absolutely no reason, Mr. Herring shouldn't still be alive today, preparing to spend the holidays with his family and friends. There's absolutely no reason. And but for the defendant's actions on May 7, 2019, he would be. You saw and heard the evidence. And all of the evidence points to one conclusion, that the defendant is guilty. Now, you won't be able to take back the videos and the audios of the 911 calls as you deliberate, but if you want to be able to listen to those again, to see them, just let the bailiff know, and we'll let you do that. But this isn't a complex case. The defendant had no right to do what she did. None. And so I'm going to ask that as you deliberate, that you find her guilty on each and every count in the indictment.
Mic drop. Now the jury's going to be charged.
To charge you with respect to the law that you must apply to the facts.
These are the rules they have to use, so these are important.
It involves quite a bit of reading, so I ask for your attention while I read. Of course, you will also get a copy of the charges to take back with you. You are considering the case of the State of Georgia versus Hannah Renea Payne, who is charged with malice murder, felony murder, aggravated assault, false imprisonment, and possession of a firearm during the commission of a felony in violation of certain laws of the State of Georgia. The indictment you are now considering in substance reads as follows. Count 1. The grand jurors aforesaid in the name of and on behalf of the citizens of the State of Georgia charge and accuse Hannah Renea Payne with the offense of malice murder in violation of OCGA 1651A for the said accused person in the county of Clayton and State of Georgia on or about the 7th day of May 2019 did unlawfully with malice aforethought.
Apparently we have new iCloud terms and conditions. Give me just 1 second. We're gonna say no.
Was the death of Kenneth Herring, a human being, by shooting him with a firearm. Count 2. The grand jurors aforesaid in the name of and on behalf of the citizens of the State of Georgia charge and accuse Hannah Renea Payne with the offense of felony murder in violation of OCGA 1651C for the said accused person in the county of Clayton and State of Georgia on or about the 7th day of May 2019 while in the commission of the offense of aggravated assault as alleged in count 3, a felony, did cause the death of Kenneth Herring, a human being. Count 3. The grand jurors aforesaid in the name of and on behalf of the citizens of the State of Georgia charge and accuse Hannah Renea Payne with the offense of aggravated assault in violation of OCGA 16521 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did make an assault upon the person of Kenneth Herring with a firearm, a deadly weapon. Count 4. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of felony murder in violation of OCGA 1651C for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 while in the commission of the offense of false imprisonment as alleged in count 5, a felony, did cause the death of Kenneth Herring, a human being. Count 5. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of false imprisonment in violation of OCGA 16.541 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 in violation of the personal liberty of Kenneth Herring did unlawfully detain Kenneth Herring without legal authority. Count 6. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of possession of firearm during commission of a felony in violation of OCGA 1611-106 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did have on her person a Springfield 9mm, a firearm, during the commission of the crime of malice murder as alleged in count 1, a felony, a crime involving the person of Kenneth Herring. Count 7. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of possession of firearm during commission of a felony in violation of OCGA 1611-106 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did have on her person a Springfield 9mm, a firearm, during the commission of the crime of felony murder as alleged in count 2, a felony, a crime involving the person of Kenneth Herring. Count 8. The grand jurors aforesaid in the name of and on behalf of the citizens of the state of Georgia charge and accuse Hannah Renea Payne with the offense of possession of firearm during commission of a felony in violation of OCGA 1611-106 for the said accused person in the county of Clayton and state of Georgia on or about the 7th day of May 2019 did have on her person a Springfield 9mm, a firearm, during the commission of the crime of felony murder as alleged in count 4, a felony, a crime involving the person of Kenneth Herring, contrary to the laws of said state, the good order, peace, and dignity thereof. Tracy Graham Lawson, District Attorney, Clayton Superior Court, August 2019. Issue and plea of not guilty. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form the issue that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. Presumption of innocence, burden of proof, reasonable doubt. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with a presumption of innocence in her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to find the defendant guilty. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to find the defendant not guilty. Bare suspicion. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raises a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Jury, judges of law and facts. Members of the jury, it is my duty and my responsibility to determine the law that applies to this case and to instruct you on the law, which is what I'm doing. You're bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented. Then you must apply the law that I give you in the charges to the facts as you find them to be. Evidence generally. Your oath requires that you will decide this case based on the evidence. Evidence is a means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during the trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. Direct and circumstantial evidence. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is a proof of a set of facts and circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. To warrant a conviction on circumstantial evidence, the proven facts must not only be consistent with the theory of guilt, but must exclude every other reasonable theory other than the guilt of the accused. The comparative weight of circumstantial evidence and direct evidence on any given issue is a question of fact for the jury to decide. Give me 1 second, I need a water break. Credibility of witnesses. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Expert witness. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You're not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive.
Question is, how long will the jury deliberate? There's supposed to be at the end there.
To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Prior statements. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. Prior inconsistent statements, substantive evidence. Should you find that any witness prior to that witness's testimony in this case from the witness stand has made any statement inconsistent with that witness's testimony from the stand in this case, and that such prior inconsistent statement is material to the case and the witness testimony, then you are authorized to consider that prior statement not only for the purposes of impeachment, but also as substantive evidence in the case. Single witness corroboration. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. Immunity or leniency granted witness. In assessing the credibility of a witness, you may consider any possible motive in testifying if shown. In that regard, you are authorized to consider any possible pending prosecution, negotiated pleas, grants of immunity or leniency or similar matters. You alone shall decide the believability of the witness. Statement of the defendant. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of her constitutional rights. Voluntariness defined. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent defendant was informed of his or her rights, as discussed below if applicable. Burden of proof as to voluntariness. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. Constitutional rights. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. The defendant had a right to remain silent. If the defendant chose not to remain silent, anything she said could be used as evidence against the defendant in court. The defendant had a right to consult a lawyer before any questioning and to always have the lawyer present with her during any questions, and if the defendant did not have money for a lawyer would have been provided for her to represent her any questioning and to be present with her during any questioning. Burden of proof as to rights. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given by the defendant. Conditions precedent consideration of statement. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights and that she understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict except for purposes of attacking the credibility of the witness or impeachment. DNA. Evidence related to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence related to DNA comparison is dependent upon many factors. Among the factors are the credibility or believability and accuracy of the witnesses who were involved with the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves that were used to form such opinions. All of these issues are matters for you to consider and determine. It is for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. Definition of a crime. The defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of the state in which there is a joint operation of an act and intention. Intent. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it did exist from the facts before you. Intent may be inferred from the proven circumstances or by acts and conduct, or it may, in your discretion, be inferred when it is a natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by law. Accident. No person shall be found guilty of any crime committed by misfortune or accident in which there was no criminal scheme undertaken or intention or criminal negligence. An accident is an event that takes place without one's foresight or expectation, that takes place or begins to exist without design. If you find from the evidence in this case that the incident that is the subject matter of this case occurred as a result of misfortune or accident and not as a result of a criminal undertaking or criminal negligence, then it would be your duty to acquit the defendant. When the issue of accident is raised, the burden is on the state to negate or disprove it beyond a reasonable doubt. Any evidence as to misfortune or accident should be considered by you in connection with all of the other evidence in this case. If in doing so you should entertain a reasonable doubt as to the guilt of the accused, it would be your duty to acquit. On the other hand, should you believe from the evidence as a whole that the defendant is guilty beyond a reasonable doubt, you may convict. No presumption of criminal intent. The defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Presumption and inferences. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within your discretion. Venue. The law provides that criminal actions shall be tried and indicted in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Clayton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence or both. Malice murder. For malice murder, the state must prove that the defendant caused the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. Motive. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. Felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault and false imprisonment are felonies, which I will define for you shortly. Causation in felony murder. You may find the defendant guilty of felony murder if you believe that she caused the death of another person by committing the felony of aggravated assault or false imprisonment, regardless of whether she intended the death to occur. There must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Aggravated assault. Thank you for your attention so far. For aggravated assault,
I think that was
the
pointed.
state must prove that the defendant assaulted another person with a deadly weapon. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. Firearm as a deadly weapon. A firearm, when used in the way a firearm is ordinarily used, is a deadly weapon. False imprisonment. A person commits the offense of false imprisonment when, in violation of the personal liberty of another, she detains such person without legal authority. Excuse me, another water break. Thank you. Firearm during the commission of crime, possession of. A person commits the offense of possession of a firearm during commission of a crime when the person has on her person a firearm during the commission of or any attempt to commit a felony, which is any crime against or involving the person of another. The offenses of malice murder, aggravated assault, false imprisonment, as alleged in these counts, are felonies under the laws of the state, as previously stated. Justification and the use of force in defense of self or others. Sometimes a defendant's threat or use of force is legally justified and so is not a crime. A defendant is justified in threatening or using force against another when she reasonably believes that the threat or use of force is necessary to defend herself against the other person's imminent use of unlawful force. A defendant is justified in using force that is intended or likely to cause death or serious bodily injury when she reasonably believes that the use of such force is necessary to prevent death or serious bodily injury to herself, or the commission of a forcible felony, which means a felony that involves the use of force or violence against another. The state has the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. If you decide the defendant's actions were justified, then it would be your duty to find the defendant not guilty. A defendant is not justified in threatening or using force if she provokes the threat or use of force against herself, intending to use that threat or force as an excuse to harm the other person. Is committing a felony. False imprisonment is a felony, which I have previously defined. Is the initial aggressor unless she withdraws from the encounter and clearly communicates to the other person her intent to withdraw, and the other person continues or threatens to continue the use of unlawful force. Reasonable beliefs explained. For the defendant's threat or use of force to be justified, the defendant must believe that her threat or use of force is necessary. That belief must be reasonable. That is, a reasonable person would also believe that the threat or use of force is necessary, and the defendant's reasonable belief must be what prompts her to threaten or use force. No duty to retreat. A person who is not the aggressor is not required to retreat before being justified in using force she reasonably believes to be necessary. Threats justifying a homicide. The defendant's use of deadly force may be justified even when there has not been physical contact between anyone. If the menacing action of the alleged victim is sufficient to create a reasonable belief that the defendant's life is in imminent danger, the defendant is in imminent danger of serious bodily injury, or a forcible felony is about to be committed, then the defendant's use of deadly force may be justified. Words alone never justify the use of deadly force, no matter how abusive or provoking. However, verbal threats accompanied by some menacing action may justify the use of deadly force, excessive force. A defendant is not justified in using excessive force while acting in self-defense. If you decide that the defendant used more force than was reasonably necessary to defend against the alleged victim's threats or use of force, then the defendant's actions would not be justified. Revenge. A defendant is not justified in threatening or using force against another person solely in revenge for something the other person said or did on a previous occasion, no matter how serious the past wrong may have been. If you find beyond a reasonable doubt that the defendant used force against the alleged victim for the purpose of avenging a past wrong and not for the purpose of preventing an imminent death, serious bodily injury, or commission of a forcible felony, then you would be authorized to convict the defendant. The court has no interest in case, by no ruling or comment that the court has made during the progress of the trial, has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. Sympathy. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in the charges. You're not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively, without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence, economic status, for or against either party. Responsibility for sentencing. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourself with punishment. Deliberations. One of your first duties in the jury room will be to select one of you to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you're convinced that it is wrong. However, you should never surrender an honest conviction or an opinion just to be congenial or just to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You're also not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messaging, websites, blogs, or social media of any kind. Unanimous verdict. Whatever your verdict is, as I said, it must be unanimous. That is, agreed to by all of you. The verdict must be in writing and signed by one of your members as foreperson, dated and returned and published. That is, read in open court. Ladies and gentlemen, to assist you in reaching a verdict, the court is going to provide you with a jury verdict form. The form in substance includes a paragraph for each offense for which the defendant is charged, and there is a place for you to check not guilty or guilty for each count. Then there is a space for the foreperson to print their name and sign and date the form. Please fill out the form in blue ink so that we're able to distinguish the original form from any photocopies. I'm going to allow you now to retire to the jury room to begin your deliberations. But do not begin the deliberations until you receive the indictment, the verdict form, and any evidence that has been admitted in the case that the law says you can have in the deliberation room. Numbers 13 and 14, you will be sequestered from the jurors deliberating in this case. Do not discuss the case with anyone, including the bailiffs. Should one of the jurors not be able to continue, you will then enter the jury room and become the 12th juror in the order that you were selected. Thank you all. It is now 4:35. I can give you a break, a short break, and then ask you to begin the deliberations at 4:45. So I'm going to recess at this time, allow you to leave. You can take a bathroom break, and then I will ask you to begin the deliberations at 4:45. And again, do not begin until we give you the verdict form, the indictment, and all the evidence that you're allowed to have. Thank you so much.
Okay, we're going to start the timer now, even though they've got a 5-minute break, because we're not going to see when they actually start. So just know that it's a little bit off. All right, couple things. I'm just looking at the plaintiff's motion they just filed in the Maya case, and it is a doozy. It's a good one. I can't see why this is not working here.
Thank you. You may be seated.
And apparently we are now in verdict watch. I think we're now in verdict watch. All right. Let me see. I can't get this to show up on my screen the way I'd like. Let's see. Let me see. Camera 8.
So, counsels, we've already selected the evidence that will go back to the jurors. I'm going to include the charges, and I believe our court reporter, Ms. Brown, has the copy of the indictment. So they'll have everything they need to begin their deliberations.
And do they have the verdict form as well?
Let me. Do you have the verdict form here? There? Yes. Okay. Thank you.
Mr. Bunches. Hold on.
Let's see. Hang on. All right, we're trying to. I'm having trouble with my replay machine, but it's showing everything purple. It's not purple. It's not supposed to be purple. It's pink. The Maya
Is there
document
anything further that the court needs to address
has quite a few fun
before
photos
we
in it.
Recess?
Including
We should have telephone
Harry
numbers
Potter.
if there are questions that arise while they're deliberating.
AC/DC.
Then certainly the court
Flash.
will notify counsels.
Gatorade.
Oh, I'm talking without being on record.
Go ahead.
That was just practice.
Okay, I'll go right ahead.
Judge, we just need to note any objections to the charge. The state did not notice any errors and has no objections to the charge.
Okay. And that's for defense.
And Your Honor, we appreciate that you gave us extra time to look at it. I think any objections we had were taken care of and corrected, and the final version was fine with no objections from the defense.
Okay, thank you, counsel. Okay, as I was saying previously, we do have telephone numbers that we're able to reach counsels if there are questions that they pose to me. Definitely, I will alert you. I will bring them back in if there's a need to in terms of explanation, but I will confer with counsels before I do so. Okay, thank you. So we stand recessed for the evening. Yes.
Recessed for the evening.
Not counsels, but anybody else in the courtroom that needs to leave, we are recessed. Counsel. Right, they're going to be deliberating, but if anybody wants to leave at this time,
No, they just usually write it on the
because all that's going to
notepad.
happen will be.
Okay, hang on. I've got Dr. Joe calling me on the other line here. Just 1 second.
Yes.
Do me a favor. The big picture.
Okay, so I have one question I was going to ask Scott, and I don't know the answer to it. But it seems like when I was younger, they spent so much time trying to get the charge correct, like what they are going to charge this person with. They don't want it to be too high, so they'd say, well, we don't think we can get that, so we're going to do this lesser one. And so they seem to be trying to get the accurate charge when they were doing that, like that. Now it seems like they shoot for the moon, and and they just say, well, if we can't get that one, then I'm sure it's going to be one of the lesser included. And so my question was, is that how it works, that you just go for the highest one possible and then let it trickle down to whichever one you can actually get enough evidence to support? I don't know. If you guys know, that would be awful. No. Sorry, I'm tired. I didn't get very much sleep. It would be awesome if you can let me know what the rules are with that. But I also found psychologically, this is a really interesting thing, that as we listen to all of these jury instructions and as we think about, like if you're on the jury and you're hearing all of these things, you're going to have, I want to call it a cascade event, but I'm not sure if that's the right word, where basically you'll get to a point where you have decision fatigue, and you will start saying, I just don't know anymore, but I have heard that she must be guilty of whatever so many times that I'm just gonna pick one, and probably about that level, and then once you say yes, it's just easier and easier to say yes over and over. And I think the opposite is also true, that once you put your foot down and you say, no, this isn't true, you haven't proven it, then it's easier and easier to say, and no on that either, you're making me stay here a really long time, you're making me go over all of this evidence when you didn't prove your case, and so now it would be easier to say no. So it feels like by creating the situation where there's going to be a lot of decision fatigue, you're either going to win big or you're going to lose big. So I think that's really interesting, that you cannot hear somebody say the same accusation over and over and over again without it getting into your head, even if you feel strongly that accusation is wrong. without, like, and flip it too, right? You can't have somebody say they're innocent, they're innocent, they're innocent over and over and again without it eventually just wearing you out and making you start thinking, maybe you're right, simply from repetition. And I wonder if that's one of the reasons why they have so many charges, is just going to wear you out and hit you with the same idea so many times that you're likely to cave on one of them. So, hi, everybody. I'm filling in right now. Scott just got a call from Dr. Joe, so he's just going to go talk to him right now, and then he'll come back, and it will be fine, guys. The great mind, the great voice will be back. Thank you very much, Inquiring Mind. Thank you, Megasaurus. It's not for the moon, though. I mean, she did commit felonies other than murder. Oh my gosh, you guys, these lights are really hot. I don't know how he doesn't sweat in here all day. So, right, that wasn't my point. The point is not necessarily specific to this case. I'm simply saying that when you have an idea put out there and repeated and repeated and repeated, eventually you wear down your ability to resist that idea. Whether you originally agreed with it, whether the evidence supports it or not, it is a common technique. When you're trying to manipulate somebody, you just hit them with that idea over and over and over again. Now, if you already believe this, or if you listen to the evidence and you find that this is compelling, I don't know that it makes that big of a difference, except you're probably more likely to really throw the book at them because you feel like, yeah, not only did I come to this conclusion on my own, but now it's been repeated so many times that I feel like I'm just really reinforced in my point of view. So I'm just saying, I think it would be better if they charged for what they felt the person, the defendant, actually did, instead of saying, we're just going to go for this and have all the lesser included, and then just by virtue of all of the repetition, we're going to have that advantage in the psychological part of the case. Should fit the actual crime. I wonder how you make this go down. Okay, there we go. He sweats out. Okay, yes, Adam, this is a possibility. He sweats out his water as fast as he drinks it. That's why he doesn't ever have to go to the bathroom. Yep, it's a strategy. They want conviction. Sometimes they don't care about actual guilt. I would hate for that to be the case, because I feel like that is a tragedy as well. Like, if some crime has been committed, and I assume there has been, if you have a court case, that is already a tragedy. And to take it and make it a bigger tragedy, that's just really sad. I think let's charge him with what you feel, what you have evidence to support, and then you shouldn't have a problem getting it. Okay, I guess you have to hit the down arrow, which means I miss everything. Sorry. Mrs. R.A., what was the name of that baking lady you were talking about on the Irrelevant with Matthew? Who's Matthew? I think you mean Thomas. What's her name? This is just such a great question. Momables, Momables. Her name is Laura Fuentes, and she has some really great recipes. You think I have a valid point? I think I have valid points all the time. I cannot seem to convince pretty much anybody else that they're valid. My teenagers especially do not care that what I have is valid. But the pressure is equal on both sides. So this sounds really insightful and wonderful, but I can't quite figure out what it's referring to. So that's possible. I'm not sure what you mean by that. There has got to be a way to make this go down better. They just want to see what sticks, unfortunately. Okay, so I see that. I see that if you are a lawyer, you want to be able to stick out, put out there as much information as you can and be able to make something stick. That makes sense, but I feel like it's almost unfair because of the psychological factor involved, that if you're just really wearing them out, then it's really just go with what you can prove. Hey, Scott, you want to borrow the mic for a second? You want your mic back? Are you done?
Are you finished with your thought?
Yeah, that was my whole thought. In fact, my thought didn't last nearly that long. I just kept talking and talking. Okay, thanks, guys. Back to Scott.
Isn't she awesome? I love her. Thank you, Inquiring Minds. Hello, Mrs. R.A. Thank you for the super chat. That is awesome. I had a quick little call with Dr. Joe, just seeing if we might be able to connect when I'm down there. And that was awesome with him. We're going to see if things line up. let's see. We are on the timer. Well, where's our timer? We're about 11 and a half minutes into Verdict Watch. So I think we're going to be surprised if we get a response tonight. Okay. Harry will never get his day job back. She asked me if I wanted to borrow my mic. So, yeah. All right. Where did we leave everything? I'm starting to build in my head my list of everything I need to bring down to Florida with me. The iPad is broken, so I can't put it on screen. I have the iPad, the broken iPad, right here, so I can see it counting. But trying to get it to register, no bueno, no bueno. But we'll figure out. Might need a new cable. All right. Let's see. A lesson to mind yours. Yes. Supposed to be seeking justice, not just winning. Convictions help re-elections. Let's see. I missed what she said. I was off on the phone, so I'm not sure what she talked about. All right. I feel like they charged her with everything to see what would stick. I think they did. I think they overcharged because most people have a hard time. I'll say most people because I think we did a poll that showed this, that most people did not believe it was malice murder. Is that right? Am I remembering the poll correctly? They did not say it was malice murder. Where's 8? Let me tease you with something. Just a quick tease. This is a screenshot of the filing from the plaintiffs that just barely came out. Yes, all the other ways that some of the same symbols are used. So good stuff here. Even going back to the Hobbit runes alphabet. It's spicy as well. It's spicy. I've reviewed through some of it. The fun part is right at the very beginning on this page right here. The defendant's second supplement should be stricken and sanctions imposed upon the defendant for raising such inflammatory and callous allegations without sound bias. We'll go into that another time. We're not going to read that. We're going to read that tonight. But yeah, Krista's like, I was doing it before it was cool. Krista, you've had the lightning for a long time. Anyway, it's a great little 29-page document. I think we're going to do that tomorrow because we have. Here's what's happening tomorrow. Wednesday, we may have a verdict, okay, and then we have not much else, and then we have to travel. Reverend, I went to the post office and there was nothing there. Oh, hey, hang on, I've got a spam risk, guys. Hello.
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 Hello, good afternoon. This is Andy from Quality Expression.
Hey, Andy.
And the reason for the call is we noticed that you had purchased a travel package a few years ago, but you were not able to utilize your vacation package.
Yes.
So the good news here is we are not charging you any kind of reinstatement fee or upgrade fee. We are just simply adding time and value to what you already have. We are removing the expiration date and lifting all the blackout dates. And we are also going to give you 2 complimentary airfare tickets. That is good for a lifetime. So do you still have plans on traveling at some point in the future?
Can I use them this week? I need to get to Florida on Friday. If I could use it to fly from North Carolina to Florida. Can you book that for me?
Oh, when are you going to use it, sir?
Well, I need to be there probably Thursday, and then I'll need to be there for Florida for court, and then I can come back on Saturday.
Oh, well, as far as I know, sir, it would take 30 days before you go to travel. but I'm not sure. If you don't mind, I will let you speak to my promotional manager.
Oh yeah, that would be great. If he can book this for me, that would be great.
Okay, can you hold the line for a second?
Sure. You guys, should I do this? Should I? We've got the manager. Hang on.
Hello, Mr. Bourne.
Yes, Jason. Oh man. They hung up. They hung up. The manager was not having it. My voice sounded too authoritative, I think. That was it. I said I was Jason Bourne. Who do they want me to be? Bourne, Jason Bourne. Yeah, it was a good attempt. All right, he said Bourne, so I went with it. I mean, what other Bourne can you think of? What other Bourne can you think of in the moment? I was going to be Dwayne, but yeah, apparently the travel certificates are in Dwayne's name. Dwayne Bond, Jason Bourne. That's how I remember. All right. I was almost going to get free tickets to Florida. Did you guys see how close that was? Hey, I went and checked my post office box, and it does not have anything in it other than a Christmas card. So I'm not sure what's if it says that it arrived or not. If somebody says it arrived, let me know. I ruined it. I was too excited. I think I need to be more hesitant and maybe turn off the deep bottom sound on the amplifier here. Anyway, man, it's a good show, Melissa. Of all the people you want to be, Jason Bourne. That's like being Spider-Man. For those not sure what's happening, Recovery Addict has asked his name be removed from that list for years. It's not even his name. It's just my number. They give out my number, and it's the same thing every time. I had one guy call. It was on, I believe, Saturday. He called and told me about the same deal, and I sort of laughed at him, like, look, you need to call back during the live show so I can put it on the air. And he's like, what do you mean? And I said, well, you know that this is a scam, right? And he's like, no, sir, this isn't a scam. This is real. And I said, do you honestly believe that? He said, yeah, this is real. And I said, then why do I have 15 different people from 15 different companies calling me with the exact same script saying that I purchased a travel package that I just didn't use? Do you really think that every person you call has purchased a travel packet and just not used it? Yeah.
Call from.
Like, well, I don't have time.
Funny story alert.
Here we go.
To accept, press 1.
Ivan, keep it clean. Keep it safe for the channel. You got a story for us?
This is the most, not ironic, but just a good wholesome story to get us off of whatever we're talking about. So I'm walking in the store. I need some eggs. I need some bacon. I need some whole milk. You know, the daily Wisconsin. Correct. Okay. And so I'm walking, and so my pops had just sent me my annual Christmas care package, which always includes the same thing: warm socks, a new Carhartt stocking cap, a new thermal top, a new thermal bottom, and a gift card to the local sporting goods store. I haven't gotten anything different in the last 15 years. So anyway, I'm walking to the store, and so I go and get the essentials. Well, here's the problem. He accidentally bought me an extra large, and while I'd like to think my pecs are, Hulk Hogan size, but
I'm not seeing that.
Yeah. No, okay, I'm not an XL top guy. Okay, I'm just not like I washed that thing in hot water a couple times. Fair
and
enough,
it's too
we're
small.
there.
Yeah.
Yeah, and we're there. Okay, so anyway, but the reason that's important is because guess how low that thing hangs? Guess what it hangs below?
Your knees.
The pocket I put my wallet in. Okay? And so, yes, now we're in trouble. So I go and pay, and I'm walking about halfway back. I'm jamming my tunes. I just lit up a Newport. Life is good. And so I'm always just like tapping my pockets, make sure I got everything. It's an old habit, blah, blah, blah. All of a sudden, no wallet. Now we have a problem, okay? And so there happens to be a bar right next to the Quick Trip, and I always cut through that parking lot on the way back home. So I stop in the bar, and I'm like, hey, and they're like, we recognize you from the liquor. And so it's like, first of all, we have to get rid of that whole thing. That takes like 30 seconds. I was like, no, we have a problem, okay? Has anybody found a wallet in the parking lot? No. There's like 20, 25 people in there, all over the age of 40, just like totally bummed for me. It was sweet, but I was still not satisfied because I don't have my wallet, okay? And so I was like, okay, I got to keep moving on. I got to keep looking for this wallet. Well, the Quick Trip that I had gotten my groceries at is like a block up the way, right? And so a block past that, right at the stoplight, I see something black in the middle of the yellow stripes. And it happened. I said, that's either a rat, a squirrel, or that's my wallet. And so I go,
your wallet looks like a rat or a squirrel?
Well,
was it made from the skin of a rat or a squirrel? No, just kidding.
From 2 blocks away, if you see a square object, like, you're just hoping, okay, maybe that was the hope of God. Maybe that was the hope of somebody just telling me, hey, that could be it. And guess what? He delivered, because it was my wallet. And here's what I think. I don't think like a truck dragged it like a block further than I'd actually been. I think somebody picked it up because I don't carry cash because, like, as I've told you, I keep all my money either in crypto or
checked
in
it,
other means.
saw nothing, and chucked it.
Tossed it out the window. So I feel like I had to do this bar a service that I just like went and bombarded. And so I walked back down to the bar, just happy as a kid with his first communion, just, elated. I can't believe I just found this wallet. And so I go back into the bar, and I walk into that bar with my wallet like Simba on the mountaintop. Like, I have it.
On the savannah. Yeah.
Oh, everybody was so happy. And, and so that's my wholesome story of living in a small town, and you just never know what'll happen.
Sometimes good comes around and bites you in the butt. In this case, it didn't, but it was good. Good job. I'm glad you found your wallet. I've got a request, Ivan, to play the verdict song, but I'm not hearing the verdict yet. What?
Oh.
I'm showing 23 minutes 56 seconds.
Well,
my daughter's saying it's time to be done live streaming. When are you going to be done live streaming? It's time to be done.
I just wanted to give a nice wholesome story. Sometimes good things happen to stupid people, and today was a version of that.
I found a wallet in the middle of the street one time. It was on. I was driving 65 miles an hour on Highway 89 in Utah. It's a little road. I think it's a 4-lane road with a big center lane. And I'm driving along, zipping probably 10 over the speed limit, maybe 20. I don't remember. It was back in the day. I think the statute of limitations has passed on that, so you can't get me. But zipping along, and I see something in the road. I'm like, that was a wallet. And I'm like, some dude lost their wallet in the middle of the road. And so I flip a U-E, we go around, come back around, and I pull over, and I run out in traffic and grab it. Sure enough, it's a wallet. And it's like one of those big fat wallets, and the outside has just been like mangled because it's been hit over and over, but it's like stayed together. And opened it up and had like all the IDs, every card, all the IDs, everything was in there. Call the dude. I'm like, hey, I've got your wallet. He's like, how'd you get my wallet? I'm like, well, it was on Highway 89. He's like, I put it on top of my car on the way to work and it fell off. I had no idea. I've been driving the whole route looking for it. But got it back to him. So we both got wallet stories. Ivan, thank you very much.
Hey, man, good for you. Good for you. Maybe it was your karma that turned it in that returned mine today.
Yeah. Well, like the next week, I washed my wallet in the washer, and I lost all the everything sort of just melted.
So maybe I somehow stole your karma. Is stolen karma a thing?
Yeah, I think it is. It's like stolen valor, only different. So
there's nothing worse than there's nothing worse.
On that note, Ivan.
Yes, sir.
Cheers. Have a good one. We'll see you. Bye.
Bye.
All right. Maisla wants us to play the verdict song. I just have to announce that this is not the verdict. Maisla just asked me to play the verdict song really quickly. I'm feeling this one. All right, no verdict yet, so we can't get the rest of it. You can't get the hype until it's over. You can't get the full build up until we have a verdict. So verdict music will be coming. Just that's a teaser. Mayla's mom. That's all you get. What's that called? It's called Right Here or something. I don't know what it is. Let's see. This is my favorite song because Scott and I did a podcast to it before this whole thing blew up. We did. Oh my goodness. We did the most probably politically incorrect podcast ever. Looking back, hindsight looking at this, we made some, I would say, poor choices about names and subjects. And it was a very early pandemic podcast, and you can just run with it that way. But all right, how about the cat song for old time's sake? What's the cat? This one? This is a good one. Now that I have a cat, it really resonates with me. Take a break. That brings it on. I think that's what we're going to do. I think we're going to wrap things up here, and we'll keep our ear to the ground. If they come back with a verdict, we'll go ahead and run with it. But they broke for the day. It's 5 o'clock right now. I think really that the jury is probably going home. I don't think it's going to be a late night here. I just don't see the judge. She doesn't work early. I don't think she works late. She's on that Jamaica time. Anyway, it's so we'll keep our ear to the ground. If something happens, if you hear something happening, shoot me a text on the burner phone. We'll come back live and follow the verdict and share that with everybody. But I think until then, we're going to switch from this song to another one like this. Like that. See, that was on the same slider that I did that. All right. Thank you all for coming to Samantha. Thank you very much. The judge has a great accent. I want her to do my voicemail message. That's how good it is. I really do. Micah Ruddle, welcome to the gallery. Thank you so much. We've got the Yellow Courthouse by your name, which means you've supported us for at least 6 months. I think it's more. It's been wonderful every day. It wouldn't be the same without you. Thank you. Thank you. Thank you. All right, I have a few things to do. I have a few things to get ready because we have a Florida trip coming up, and I need to run around my house and basically I need to find things like this. Like I need this box right here. You know, you never know when you need an SDI to HDMI bidirectional 3G converter and the power supply that goes with it. So I'll have to do all this, running around and find everything I need and get it packed in the same place and loaded. I'm gonna have to take the pen from Rob. Let's see, a few other things. I've got cables all over the place. A few of these items, probably that camera, this laptop, the phone, a few chargers, connectors to connect everything. Anyway, I've got my work cut out for me, and we're gonna get it done here tonight because I want to be ready for when it's time to run. Let's see, I need to run around the house and wrap presents. Says homeschool ground zero. 1, 2, 3. Not it. Don't forget your milk flask. Oh, milk flask. Milk flask has to come with as well. We'll bring everything. I'll bring my gavel. Will the judge be impressed if I have my own gavel? I've never done this before. Anyway, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. It'll be tomorrow morning, bright and early. We'll see you there. Thanks, guys. Have a good one. Bye. Oops. Now bye. What did I turn on there? What's in the middle of the screen? There I am. There I'm not. There it's gone. I fixed it.
Scratch all that. Oh, that was terrible. I apologize.